Hey, welcome, jerks. How you all doing tonight? How's everybody doing? I'm feeling good. Today was interesting. We got to see Lally on the stand. He was getting cross-examined or whatever we're calling this, deposed, deposition. That's what it was. Deposition. That's the correct term here. He's getting deposed. Evidentiary hearing. Very skilled attorney. We all watched it. We were all watching it all day. A lot of chats going. We saw our attorney Bederow with attorney Melanie Little. A lot of us were watching it there. We had it also streaming here. Broken Baker had it streaming. Everybody had it streaming. Everyone was watching this new murder trial in Massachusetts with assistant district attorney ADA, I guess his name, Adam Lally, getting a bunch of questions about Michael Proctor and about warrants. And we got the guest. We got the one you want. We got him ready. He's here. Let's bring him up. Attorney Mark Bederow back on the Young Jurks to answer some questions about what we saw today in court. Hey, Mark, how you doing tonight?
Okay, how are you? How was your weekend?
Good. Had a good time. Just chilling. I've just been kind of relaxing since
Yeah.
Karen Reed. I'm taking a lighter schedule and everything. It feels
Well,
good.
how was your Monday? Entertaining?
Today was fun. You just get to kind of kick back and like this is like free house money. Like it's like after Karen Reed, there's no stress on that. And you just get to watch the same group of characters just they're just lighting themselves on fire,
Yeah,
right?
self-immolate. Yeah, they're bad, but let's be clear. This is an Adam Lally story, not a Michael Proctor story. He's the prosecutor, he's the lawyer, he's the one with the professional and ethical obligation to disclose evidence, not Michael Proctor. Obviously, Michael Proctor can't destroy evidence or not give it to the DA or whatever. But the way this works is the buck stops with the prosecutor. And so this is a Lally story, and he's the one who is going to suffer the consequences. And Proctor already has anyway. Kicking Proctor is like kicking a dead horse. He's gone. He's dead. It's like kicking Sonny Corleone after he's been hit. What's the point? He's not the story here. The story is 100% Adam Lally.
You have much explanation on like the warrant. Just starts with the six warrants that he was looking for. And he didn't seem to recall any of the conversation he had with Proctor about it.
It all starts at the beginning, which in this story is the flawed procedure or lack thereof and process in that office. Why would you delegate the task of search warrants exclusively to a state trooper and not have a prosecutor involved in that process? For any number of reasons. Number one, if the prosecutor prepares the warrant, has the trooper sign it, makes a copy of it right out of the gate, I don't need to ask the trooper for the warrant. I have it. That's number one. Number two, you want to make sure that there is probable cause contained within the warrant. You want to make sure it's drafted properly. You want to make sure you don't get too cute. You don't reveal things as a prosecutor you might not want to reveal, or say things you don't want to say, or make sure there are things that you do say. Why would you outsource that to somebody like Michael Proctor rather than an experienced prosecutor? I mean, in the office where I come from, the ADAs wrote all the warrants. Prepare it for the officer, go over it with him, have him or her sign it. You sign it. The prosecutor would sign the warrant. Bring the detective down to court, and you know who else would go to court? The DA, a lot of the times. Just make sure if the judge has any questions, which the judge has a right to do. Most warrants are rubber stamped, but why wouldn't you do that? And instead, you're left with a situation where the same prosecutor who was part of the railroading of Karen Reed and did things in that case, which clearly, well, I say clearly, in my opinion, I think most sensible viewers would agree, that did things that were improper, unethical, whether it relates to Sally Port video, whether it relates to eliciting false testimony from a sergeant who was involved with inverted video, whether it relates to shenanigans of not disclosing other video that you knew or should have been aware of, whether it relates to an officer from another police department, from Dighton perhaps, about what he clearly implied or told you and what you didn't disclose to the defense. I mean, we could go on and on. At what point do you throw your hands up and say, this guy is either shockingly incompetent, he's clearly indifferent, and, you know, is he compromised or not? Either way, in any of these circumstances, he's not fit for duty. And it's just another stain on an office where you can't even recognize the stains anymore because there were so many that it's become the same color throughout the board that you're looking at. You know, we'll get into the details clearly, but what you saw today was just disgraceful. And the idea that this man is claiming, I have no freaking clue where 6 search warrants are related to a homicide case that he's been prosecuting for years until recently or whatever it was, is there's no excuse for that. And there's some other critical facts which really are disturbing. The defendant in this case, who I have no opinion on, I don't even remember his name. I don't know anything about his case. I don't know if this is a shooting, a stabbing, a car accident. I don't know, and frankly don't care. He's incarcerated, or was incarcerated. I know he got out for years without being granted automatic discovery that he should have had at least 3.5 years ago. And that this prosecutor today, who just happens to be part of the railroading of Karen, until last month had no idea, according to what he says. The same guy who said, I had no idea that Michael Proctor had, the same detective, of course, had any of the Sallyport video stuffed in his back pocket for 2 years. Remember, in Karen's case, I knew nothing about the video for 2 years. Well, do you believe that in light of what you're learning today? I mean, what's with these guys? The other
Something off. Yeah, I just want to cut it because I think you made such a good point right at the beginning that we weren't thinking of. Like, these warrants are legal documents. Of course, the DA office should be in on that. They should have been on those 6 warrants. Why weren't they? Like, why do you think this office fucks up like everything? Like, it seems like that would be basic. You're right, especially in a murder trial.
I may be biased, or I may come from a different culture, which has much bigger departments, both DA's offices, bigger cities, bigger police departments, whatever the case may be. Doesn't change the point, which is, I don't know why and by the way, we're talking about Norfolk County, Massachusetts, suburban Boston. We're not talking about, you know, rural Mississippi. Let's be honest.
This is area with money.
Yeah,
they got money.
This is a sophisticated area with a large office, with a large budget, with presumably competent people, competent whatever. The point is, why would you not have the prosecutors be involved in preparing and maintaining search warrants in a murder case? That's unheard of to me. Now, again, this may be another one of these, you don't understand Massachusetts legal culture, which guilty is charged. That's for damn sure. I mean, you know, apparently I don't know what gets legally filed and what doesn't, which somehow demonstrates, you know, I'm some kind of idiot, you know, according to recent events, which is a whole nother issue and stupid beyond belief. But the point is, I don't know why you would not have the prosecutors do it. I don't know why you would have the same detectives from the same state police unit encamped in the DA's office. So you're working with the same people all the time, which creates a culture of too comfortable, which can lead to corruption. And it can also lead to, I'm afraid or embarrassed or unable to confront. Because what you heard today from Lally was, you know, he gave the trust me bro defense from Proctor. He told me I had it. He said he'd get it to me and I accepted that. Well, maybe if you were less friendly with these guys and more professional, you might say, dude, I'm the prosecutor in a murder case. There were search warrants that I'm obligated to disclose. I need them now. Not next week, not next month, not next year, or the year after that, or the year after that, or the year after that. I mean, this is unheard of. And they're not even done with the cross-examination of this guy. But based on what you heard today, his attempt to explain, his absolute indifference, I mean, just his demeanor, which is just one of whatever, I'm thinking about lunch, none of this really matters. I've changed my policy. I'm more careful now. This is a guy who's been a DA for 20 years and is just figuring out that maybe I should, get off the schneid and pay attention to what my ethical and professional obligations are before on a murder case. He should be terminated. There's no question. His old cases should be reviewed. Lawyers who represented old murder defendants or even other cases ought to be reinvestigating them, or other lawyers should be retained for that purpose. And then the final bow tie before you kind of focus in on specific points that I think is important. What you heard today involved Lally and Proctor, two names well known to all these people because of what they did in part, or what they're responsible with Karen. This came first. Okay. When this started, Adam Lally didn't know who Karen Reed was. Michael Proctor had no idea who Karen Reed was. So Karen is not a one-off. There is a systemic and pervasive problem at the highest levels of the DAs in the DA's office and the now disgraced terminated trooper, obviously, but at the highest level of detectives who investigate these cases. And all they do is screw up, whether it's intentional, on purpose, and they don't give a shit. They're completely indifferent towards it. And the idea that some guy could be rotting in jail for that period of time without getting discovery that he was entitled to is disgraceful. And you see it happen in cases that, with the lights shining the brightest, like Karen's case. This case is only shining a light on it because of Karen, and it's Proctor and Lally. It's the only reason. This wouldn't be in the news otherwise. This would be, one of Lally's time to make the donuts cases. Nobody would care. Unfortunately for him, another real lawyer got involved in this case who's aggressive, competent, and goes for the jugular, as she should and did, and will do so again when it continues, I imagine. But you have to wonder, what about the cases that operate in the darkness? People who don't have high-profile lawyers with access to getting publicity or attention or as much experience in these matters, or cases that are not that interesting. I mean, this is happening in cases where people are watching. That should scare the hell out of you in terms of what's happening.
They don't watch
where the public doesn't give a shit.
Yeah, exactly. We've getting a lot of questions over here about Lally himself. We've watched a lot of the other, you mentioned Proctor. We've watched a lot of these guys, Buchanan, Tully. They're getting demoted. They're getting moved around. They're getting investigated. But this question keeps coming up. How long before Lally is on administrative leave, or how long before Lally resigns? Is there anything that's going to happen to him like this?
Listen, I mean, again, far be it for me to put myself in what Michael Morrissey would do. But sorry, somebody rang the door, so Winnie and Lola are a little jacked up. Lally should be terminated, or he should be asked to resign. What you saw today, there is literally no defense for. Okay, he had automatic discovery in 2021 that was in his actual possession, of which he had actual knowledge and which he did not disclose. So you can try to pin it on Proctor, but that's all a distraction. He knew it was his obligation and he didn't do it. And then when you heard him try to explain it, and he said, I talked to Proctor about it. And what did he say? Well, I got parts of two. By the way, parts of two.
Parts of two.
What the hell does that even mean? And how does that not lead him to say, excuse me, where's the rest of this? Why did I get 3 pages out of 6? I'm making those numbers up. I don't know how many pages. Why? Where are the rest? What are we doing? At one point he said, I did finally go to the state police and meet with him. And he said he'd send it to me. How do you leave the building without the warrants and say, no, you got to get it now? I have to turn this over.
Yeah.
Okay. How do you not take the 1.5 that you got and provide that to the defense, which would have led to other questions from the defense attorney saying, why are you giving me 1.5 warrants are you even looking at what you're doing? Do you even care? Because when you watch his demeanor, he doesn't care. He's just, I don't know, and I don't remember. I didn't even review much before testifying today. You know what that tells you? I don't care. I don't want to even know an explanation. I don't want to try to come up with one. I just want to get through today and get the hell out of here and go, suck down another lung dart, have lunch, and go home. He doesn't care. And the question is, does Michael Morrissey care? Probably not. But, the viewing public certainly cares. So we'll see. But I don't know how you could ever assign this guy another serious case ever again. He's been in the office 20 years and can't figure out where there are search warrants that he had actual knowledge about and mentioned in the grand jury in 2021, whether they were disclosed at any time prior to June of 2025 to a mostly incarcerated defendant. It's inexcusable. It's outrageous. It's unethical. And I would think he's going to have a serious problem beyond what's going to happen. And he's going to get tattooed on a ruling in this case. And I don't know what the judge is going to do in terms of the murder indictment. I don't even know if the material that he didn't disclose, whether the defense was prejudiced in the sense of there's valuable information that they could have used, which now is gone because time has been lost. I don't even know, but I'm just talking about the conduct of the prosecutor and the lead detective. And these people at this point are cartoon characters. This can't be real, that this is how they prosecute murder cases. And it's very real.
People are noticing Mr. Bederow is proving how dogs react when people are at the home. Poor Chloe. And everyone's dogs, I guess, are barking, hearing your dogs bark when he.
My dogs, your dogs, the viewers' dogs.
Everybody's barking, though. Everybody.
If you ever watched the movie 101 Dalmatians, every dog for like 30 miles in Greater London, passing the dog code sound. Every dog in the world except, the Albert family dog apparently barks when they hear things. Whatever, but
definitely. Here's one from Sharon. I'm looking at that one. I'm like, because I have an Aunt Sharon. I'm like, is that my Aunt Sharon? I don't think it is, actually. It's funny. Same name. Mr. Bederow, is it just me or does Lally have allergies to the Rule 14? It's insane.
I don't even know with him. I don't know whether it's an allergy or whether he has disdain or he just doesn't care. I can't fathom any good faith explanation for how he can explain at no time did I maintain possession of the warrants, disclose them. You saw there was some evidence in the hearing today in which he represented to the court that I'm basically done with discovery. I mean, I'd like to know the good faith basis for that statement. You can't make representations in court without having a good faith basis. That's unethical. At this point, and he says, I don't know. If I said it, I must have thought it. That's not good enough. He didn't think about the search warrants then. You didn't think about the 1.5 warrants that you had. Listen, he needs to go. I mean, this is what he did in this case and what he did in Karen's case at the exact same time. Okay, roughly same time period, at a time when he had more than 15 years of practice as a prosecutor, handling high-level cases. This is disgraceful, and you wouldn't believe it unless you saw what happened in Karen's case. You wouldn't even believe it. And this is red meat, by the way, for the looming 1983 suit, which I assume is coming down the pipeline at some point.
What'd that look like?
Well, if you want to sue the DA's office in a federal civil rights claim, you have to, it's very hard to just sue them. You have to show that there is a pattern of negligence or a lack of supervision, a negligent supervision and unawareness that led to a systemic violation of defendants' rights. Well, this is a gift. I mean, you have Lally and Proctor, you know, some would say Tweedledum and Tweedledummer together, 2 cases in a row, doing what amounts to the exact same thing, not turning over important discoverable evidence, possibly exculpatory, I don't know, and then claiming, I don't know what's going on. I had no idea. Both cases, Lally blames Proctor. I don't know. I didn't know. And so now you look at it and you say, who's running the store? Why don't they know? Are these people trained? Do they follow the law? Are they aware of the law? Are they aware what Brady is? I mean, I would have loved to have seen some questioning if the judge would have permitted it. What's your understanding of Brady? What are your obligations? Are you familiar with the duty, also the good faith duty to investigate when the defense believes there's Brady? I mean, you have an affirmative obligation as a prosecutor under Brady and the cases and in the Massachusetts cases as well to make a good faith inquiry about the existence of Brady. It's not a good faith inquiry to ask Proctor, where are the search warrants? He says, I don't know, I'll get them to you. And then he gives you 1.5 out of 6. He says, I don't know. And then Lally says, well, I don't know what happened after that. That is a textbook lack of good faith, a textbook lack of due diligence, and an egregious violation of this guy's rights, under certainly Rule 14. I don't know if it's Brady. I have no idea. Don't even know. I don't know what's in the warrants. Don't know anything about the guy's case. But the just incredible conscious avoidance of his obligations, the complete indifference to his obligations, the lack of intellectual curiosity of what he was doing, the lack of even attempting to show up today and at least attempt to have an explanation about what happened is disgraceful. You pay his salary. And this guy had too much to do to even look at the file and try to offer an explanation in front of a superior court judge, some guy who sat in jail for years, about why you didn't give him the evidence. Okay. And the other thing that you just can't get out of your mind is to say, how ridiculous is it now? Not that it matters because there was an acquittal, but how ridiculous is it now that Karen was denied the right to an evidentiary hearing with Lally, McLaughlin, Brennan, Proctor, Tully, and so on, where these same issues would have been fleshed out and all could have been revealed back then. And it also, if that had been done, would have given a ton of red meat for Ms. Scapaccio to use today to show the pattern of what Lally does, okay? Which obviously will cast doubt on his credibility about, I don't know, I asked him and, I just kind of waited and, my trust me, bro defense.
Frustrating. Yeah, I think he said at one point. A little frustrating.
What? By the way, what does that mean? It's frustrating? Why is it frustrating? You are the prosecutor. It's your obligation. The answer is put on your big boy pants, reach between your legs, count 1, 2, and then go to Proctor and say, turn it over to me now.
What the F? I'm not leaving here until you give it to me. I'm going to be in your face, man. Give me it.
Say,
it's a murder.
I'm in charge here. The prosecutor, and this is the problem with the comfort level, the way they're set up with the state police in the same building, and they're all donating money, kicking up to the boss, and they're all texting each other, locker room stuff. This is the overall problem with this. Is Lally afraid to confront Proctor because, he's my bro? I don't know. But the reality is when you're the prosecutor, you're in charge. It's your neck on the line. You need to go to the police officer and say, give me the evidence now. And if he won't do it, you need to go up the chain at the police and say, what am I doing here? This is a murder case. Where's the evidence? And if that doesn't work, then you need to go up your own food chain and tell Morrissey, if that's what it takes, to do something productive and call over there, whoever it is, and say, what is the matter with you people? Why are we not getting search warrants that are discoverable in a very important case? I mean, there could be a very violent criminal who's going to go free because Lally and Proctor are incompetent or worse.
Now, I was looking at your shirt getting hungry, but I guess it's not a real food chain. It's not real.
Well,
It's
you've
from
obviously
Breaking Bad.
seen Breaking Bad. Yeah, no, this is Los Pollos Hermanos. This is a chicken restaurant in Albuquerque, New Mexico, which was the front,
Really,
a legitimate front for Gus Fring's meth business. Yeah, you need to watch Breaking Bad. It's a real restaurant in
I watched a
Albuquerque.
little bit. Yeah,
It's called
it,
Twisters, though. It's not called Los
it's
Pollos.
a different name.
Yeah,
It's
it's
like
called Twisters.
Cheers wasn't really Cheers, but
Right.
they eventually changed it to Cheers.
Cole and Finch. Yeah, right.
Yeah,
But no, Los Pollos Hermanos was Gus Fring's legitimate front for his business.
I wonder if they're gonna change the name to.
No, it's been Twisters for years. I mean, I haven't been to Albuquerque since college, but I really, really want to go back and go on the. They actually have a Breaking Bad little, cheesy tour.
Area.
I need to do that. Yeah.
Oh, you definitely need to.
Yeah.
If you got
Oh,
the
yeah.
spirit, you gotta do the tour.
I want to go there. I want to go to this place called the Dog House, which is like a hot dog stand that is like this real sleazy bikerish kind of thing. I won't bore you with all the details, but no, this is not this is pure Breaking Bad stuff.
People seem to like it. They're enjoying it. Yeah, I need to watch more of that. I watched a few episodes back in the day. I did like it.
Best show you'll
one of
ever
those-
see. It's
Yeah.
it's the best show you'll ever see. I'm watching Landman now. I like it, by the way, a lot. Good show.
New one. You know what I just watched is Amy Bradley is Missing on Netflix. Have you seen that one? That's a true crime type mystery.
Believe it or not, this is really weird. I'm not really that ironically a big true crime person.
Me neither. I'm on this one because they're coming on the show, the brother. But yeah, me neither actually. But there's some stuff I'm interested in. It's funny. It's like you get your little ones that you're interested in.
Yeah,
I like the missing persons ones. It's just like it's fascinating.
like
where is this person?
It's case by case for me. It's like depending
exactly.
And I mean, this one was just interesting because it was local and. Yeah, I mean, we've been down this road before.
The police corruption. I mean, that's a big one too. Like, who can believe it? And
yeah.
I'm the same way. It's like case by case. So you mentioned some other things too, like revelations today, some surprising things. Have we mentioned everything? Like, what were some of the other maybe revelations from today that I might have missed?
I mean, from today, to me, I don't know. I don't know what else I could have been referring to in terms of what today, but I mean, just watching this was so disgraceful. I mean, it's stunning about and the regularity that these things happen in this DA's office. I mean, I'm at the point where I can't even fathom the possibility that come 2026 that Morrissey will be reelected.
No, it's not happening.
If that
I say he's got like a 0.1. He's no way. He might run though because he's crazy. But
if that happens, you people in Norfolk County are fools and deserve everything you get. Okay,
he's not going to win.
How you could have any confidence in what these people are doing about anything is beyond me. I mean, in many ways, the suppression of evidence in this case, again, I don't know how material it is. I don't know how important it is, but just on the merits of what was withheld for the amount of time it was withheld with a man in jail and all of that and search warrants, just on that analysis alone, it is beyond comprehension that this can even be real life. It's 1,000 times more unbelievable than the evidence, how it was suppressed in Karen's case. This story you heard today is beyond belief. It makes zero sense. I mean, and that's why when I tweeted about it earlier, I said, if you believe Lally, I don't know if that's better or worse, by the way. I mean, it's kind of like, 6 1/2 dozen of the other. You either believe him and just that he just doesn't care about anything and is so incompetent and so indifferent, or you don't believe him and you say him and Proctor, for whatever reason, just don't turn over evidence. I don't know which to credit or not credit, but they're both equally bad and they're both worthy of being gone. And, again, I think it's real important that people realize including all you, trolls and haters and people who think Karen Reed causes cancer and global warming, you types. What happened today involves some regular dude that you've never heard of, you never otherwise would have heard of. He's just some dude, right? There's no alleged conspiracy of this that you all want to dismiss. And it occurred before any of these guys ever heard of Karen Reed. And Lally and Proctor are just gross in the performance of their duties. They have no integrity in what they did. They have no concern in what they did. And these are the same people who railroaded Karen Reed. And when you listen to people like me and you and others complain about these guys, it has nothing to do with Karen Reed. So spare us the bullshit. These guys just need to go.
Absolutely. And look, this gentleman, Mr. King, is accused of killing somebody in front of this person's mother's house. So imagine, like, the thing that gets me going on this is I'm looking at it like you just went on and on about how John O'Keefe's family, but you don't seem to care about this kid's family that got murdered right in front of his mother's house. Like, I'm wondering if the mom's watching this. I don't know much about this, but this is what I heard, is that it happened right in front of this kid's, this dude's mother's house. And this is what we're going to be dealing with. People are going to get away with things because we have terrible police and DA that don't know what they're doing.
I don't know if it appears they don't. I mean, it's certainly,
or they don't care. They don't care.
It appears that Lally doesn't know what he's doing. Michael Proctor knows exactly what he's doing. He's being told, if you believe Lally, to turn over evidence, and he's not turning it over for years, for whatever reason, whatever the case may be. But I agree with you. It's also very obvious. Neither one of them cares, could care less. Again, they consciously avoid their responsibilities. They're completely indifferent to their responsibilities. Oh, leadoff home run for the Red Sox, by the way. Just sorry.
Wow, they're doing good.
Yeah, they just don't care. They're willfully blind, consciously avoiding. They don't have any intellectual curiosity. You can frame it any way you want. But what you heard today was from Lally, there's no real concern. I was frustrated. I was so frustrated that I did absolutely nothing about it. Okay.
Another email.
I was so frustrated that when Proctor gave me a affidavit, whatever the hell that is, right? Not a full affidavit.
Yeah. That's a new one. Affidavit.
I just kind of accepted it, shrugged my shoulders, and threw it in the file and let it go. Right? I didn't make any inquiries to him. I didn't notify the defense. All these other things he should have done, he never did. He was frustrated. No, he wasn't. He doesn't care. They are completely indifferent. They are clearly receiving negligent training. It's obvious that the upper levels of the DA's office don't know what's going on. I mean, who's his supervisor? Where was the senior ADA to say, let's talk about, some of these murder cases, what's going on? Is everything okay? Have you turned over this? Or none of that's happening. That office is a train wreck. Okay. And you have to feel bad for the good people who work there. There must be some, I assume, but
left.
Look what's going on you saw it in Karen's case. You're seeing it in, what is this guy's name? King?
Yes. King.
What's his name?
I think it's Amari. Is it Amari? Okay. Or is that I'm getting mixed up with someone else, actually? But his last name's King.
Okay. So you saw it in King's
Mr.
case.
King.
You saw it in that. To some extent, you saw it in the not even case, but whitewashed investigation into Sandra Birchmore.
Sure.
And by the way, it's happening in Brian Walsh, which is going to be the fiasco to end all fiascos if that evidence gets suppressed because the judge doesn't credit the so-called bad guy rule, which oftentimes comes into play and makes judges, very nervous about issuing decisions that could have substantial consequences, which would almost certainly in this case lead to suppressing virtually all the evidence against a, criminal who, presumptions of innocence and all disclaimers aside, appears to have made some really disturbing searches and engaged in some pretty disturbing conduct that I think most sensible people would lead them to believe, without hearing more, that there's a good chance that he murdered his wife and then dismembered her and, chopped her up and put her wherever he did. And the same cast of characters on some level, not Proctor per se and not Lally per se, but the same star players from this whole orbit are going to screw up that one. They screwed up Birchmore. They screwed up Karen Reed. They're screwing up King. Where does this end?
I was looking to look it up to see what his name was, and then I realized, oh, just look at the chat. And everyone's telling us Miles King. Miles. It's spelled interesting. Myles. Miles King is his name. Yeah, and then you're talking about Brian Walsh too. Like, this could go sideways. There could be several people that are guilty of the worst crimes getting free. I mean, how likely is that? Do you think that it could go that sideways?
So I haven't done a deep dive into Walsh. I mean, I've learned a little bit more about it and heard some more about it earlier today from Melanie. What I've heard is very concerning if you want, the accused to be found guilty. And if the judge follows the law, there are going to be some serious problems, because my understanding, and if I'm wrong, people will tell me, but my understanding is that, Walsh went out and got a lawyer, which is fine, a real lawyer, by the way,
Right.
Who he then agreed to give what we call limited consent to a very narrow search of his phone, which was put in writing as it should have been. And then my understanding is that the state police then ran roughshod over that and just did a full extraction way beyond the consent that was granted. They then, looked under the kimono where they weren't supposed to look and found very incriminating evidence, which they acquired illegally. And then they used that illegal evidence, which led to other evidence, which led to a search warrant where they included all of this illegality, and the warrants led to more evidence. And there is a very, very nasty, nasty concept, in the Fourth Amendment, which is called fruit of the poisonous tree. And, it's the exclusionary rule. And the concept is very simple. When the cops violate the Fourth Amendment, with certain exceptions, which I'm sure the DA is arguing in this case, there's a remedy. And the remedy is that the evidence gets suppressed, and any evidence that was discovered, as poisonous fruit, essentially from the bad evidence, would also be suppressed right on down the line, unless that evidence is independently discovered, inevitably discovered. We would have found it anyway, or what they call attenuated. There was a different way to get there, and there was a break in the action, so to speak. And those are the exceptions which often allow that. But if that search warrant is loaded with poisonous fruit from an illegal search where the consent was violated, which would be a Fourth Amendment, that'd be an illegal search, then the warrant on its face could be invalid, the affidavit. It is very possible that the affiant in the warrant, which I have not seen the warrant, did they not tell the truth? That could lead to what's called the Franks hearing. And I don't even know who sought that search warrant, whether it was Proctor, Tully, whoever, Buchanan, whoever. That could lead to a problem. And if a judge is following the law, that could very well lead to all the evidence, starting with what we saw illegally on the phone, anything connected to that, all gone. And if all of that evidence were to be suppressed, there may not even be sufficient evidence for prosecution. I don't know if it's that bad, and I don't know enough about it. I'm actually more curious now to look into it, but that case should be getting a lot more attention, because this is like code red. They really screwed up. And if I'm also led to believe that that's the case where Buchanan testified that, well, the lawyer told us, orally that we had more consent, it was okay. If that's accurate, meaning that's what he claims happened, there is no way it is literally and factually accurate, because there is no lawyer worth 2 cents.
Yeah. Yeah.
Okay. Certainly not a real lawyer. Certainly not one who already put it in writing, who would say, "Oh yeah, about that, go ahead,
Yeah. Go ahead. Do everything. Yeah.
But
Yeah.
I don't need to put that in writing.
You don't need rights. My
you
client doesn't have any
don't
rights.
worry
Let
about
him do whatever you want.
you do you, and don't worry about us, because I'm getting paid to, sit here and, do nothing." There's no way. I'm telling you, there's no way. And my understanding is that this lawyer, who no longer represents him, which is fine, testified at this hearing. And it doesn't take a genius to understand what she would have said, which was the consent given was the consent in the writing.
Yeah, to get the text
So
messages. That's what it was about. And they looked at everything else.
I would pay serious attention. If what I said is accurate, that's my understanding.
It's accurate from my understanding. Yeah.
Walsh case, they are in deep, deep doo-doo with this. And, they can, now look, they're going to argue, well, it's inevitable discovery. We would have found it anyway.
We would have got a warrant eventually. Yeah.
I've never looked up Massachusetts and inevitable discovery and whether it relies on federal law or it has a tighter constitution, whereas the defendant is entitled to more. I can only go by what I'm familiar with in New York. And inevitable discovery does not work, at least in New York, when you are relying on an argument that, it's inevitable that we would have discovered something, but your basis for that is it relies entirely on the bad evidence. Like, you can't make that circular argument to say it's inevitable, if we didn't screw this up. And well, maybe. Now, could they have gotten a warrant for his phone? Maybe. But can you just naturally assume that this is what was going to happen? You never want to be a prosecutor in a murder case, and rather than simply relying on we had valid probable cause to get a warrant, we're going through these backup technical, generally weak arguments of it would have happened anyway.
Yeah.
The fact that in the Brian Walsh case, that's what they are, is it doesn't matter. We would have, it still helps us. They're basically saying, Judge, there's a bad guy rule. Don't forget, there's a bad guy rule. This is a bad guy. This is a murderer. He chopped up his wife. But that's not what judges are supposed to do. And it's not what an appeals court would be likely to do either. The bad guy rule, the higher you go, the less impact the bad guy rule generally has. Appellate courts often, we saw it today in the Second Circuit in New York on the Eton Pat's horrible missing kid case, which was like the biggest case forever in like late 70s. That poor kid in New York in Soho who went missing and nothing happened. And then in 2012 or so, the Manhattan DA brought charges. There was a hung jury, a retrial. Guy got convicted, I think in 17 or 18. Today, after all these appeals, an appellate court in federal court reversed the guy's conviction based on a faulty jury instruction. So the bad guy rule does get less the higher up you go, and that'll be the case with Walsh too.
So does that guy getting released in New York for that?
Well, the judge basically remanded it to the district court, which heard the habeas corpus petition and said, you need to order a new trial, instruct the DA within a reasonable amount of time, whatever the hell that means, or alternatively order the state authorities to release him from custody. I imagine the DA will say we intend to retry him, which will keep him in the can longer. And then they'll have to figure out if the case is viable or not, within a couple of months. And if it is, indicate they're ready to retry him. But the point is, the higher you go up the appellate food chain, judges are more willing to hold their nose and do the right thing.
Because I just noticed Mark's solo cup in the back. Is that one? Where is that? Is that from Kirk, or is that from someone else?
No,
Your own.
it's from a family friend who watches you and others who came to visit us a few weeks ago, and she brought a bag of goodies, including the red Solo cup, which is actually it's like it's hard. It's not like
So it's like one of those Kurt ones. The Kurt's got those uncivil laws selling them on it. When he
you
came
know
on and went through all his products, I was just shocked. Like he's really
she
done up
may
the
she may
merchandise thing. I'm lazy.
she may very well have gotten it from him, and if so,
Yeah.
Mindy, if you're watching, thank you again for the cup. I traded one of the former what used to be two rubber ducks behind me. I traded.
Bingo. I gotta get some rid of some rubber ducks too. I still got. I know every time we go out, do people give you just rubber ducks everywhere you go and when you're
I
in Dedham?
I get all kinds of weird, interesting letters, gifts,
Oh,
emails, phone calls. You'd be surprised. But the rubber ducks I thought were funny in the Solo cup, but it
it's hilarious.
is what it is.
I got a
But
Christmas ornament I left behind at the last one. I feel really bad to this person. She made a really nice Young Jurks, but I didn't want to take it because you lose it or break it when you're out there. So I'm like, you got to get me when I'm going back to my car.
yeah, no, I get all kinds of interesting messages, mostly kind and good, but
Yeah,
some not
people
so.
are so nice. Mostly,
Most,
most people are nice.
not everyone.
Not
Not,
everyone. Do you
you'd
want
be
to talk about some of the not nice people? Because you were getting some pushback. So from the Twitter school of law people, they were upset about your no, I don't know. They pushed it the correct. It's funny because you wrote this Bederow letter about this woman, and then she's the one pushing back, which is crazy. It's like, have you ever seen
listen.
where that happens? I mean, this is so bizarro. This is
There's really little to be said about
okay,
her. I mean, she's involved in a case.
right?
All I can say is I'm me and she's her. You draw your own conclusions, okay? Take it for what it's worth, but not all of them who have this concept of what a discovery demand is. And a lot of times it goes in letter form because it's addressed to a prosecutor because you're telling them there's notice for this. And then if it doesn't get dealt with, you have a court date. And then you say on the court date, Judge, we tried. This is where we are. So I don't think I'm breaking news here or rocket science, but when these issues have already been discussed in court and there are problems, some might say it's actually efficient to notify the court and the judge who's been dealing with a discovery issue as to what's going on in advance of the court date. And the way you do that is by providing the court with the issue.
Notice.
And that can happen in any number of ways. It can happen in a courtesy copy of a letter, but another way where I come from is you file it with the court. Now, in this particular case, the judge doesn't want non-formal motions being filed. Okay. How that translates into, oh my God, this is a joke and it's been rejected. I mean, honestly, as I said, you people, you do you, and you, if that makes you feel better and you think that's important, then God bless you. We'll worry about us. We know what we're doing, and it's they are what they are. It's quite comical actually, but no, I don't get messages about that kind of stuff. Those are more like Twitter messages, just about I'm apparently a moron and got rejected and writing crayon and all that kind of fun stuff.
So funny.
I mean, look,
She's sitting on the couch. Is she on the sofa? I mean, come on.
I mean, I'm whatever. Again, there's really nothing I have to say about that individual,
Yeah.
or some of these other ones, because I don't need to. The record of work and circumstances speak for themselves, and the public is free to draw whatever conclusions they want to draw. And if Twitter trolls and people like that think it's a sick burn that the Massachusetts filing rules in this case are a little different than what I'm accustomed to, and draw substantive significance from that, if that's the right word, draw like, oh, that's actually an opinion about the merits. I honestly, Get hobbies, people. It's a little more sophisticated than that.
Like even a part-time job, like something you can make money, yeah, like a hobby you make a little money at, like I don't know,
I
Grubhub or something, like
Yeah,
like
I mean,
DoorDash or Uber. I don't know, find something to do.
social media is a fascinating
It
place.
is.
What do you say, right? I mean, it's look, where I come from, it is very commonplace to handle disputes or attempt to handle disputes, without the intervention of the court, while at the same time keeping the court informed on what's happening. There's no reason not to. There's no reason not to inform the court what's happening. The other reason you would do something like this is to keep a record of everything. Okay. So in the event down the line, evidence is not disclosed. I don't know, like you saw today, right, at the hearing, that you have a paper trail and a record, and to say this was demanded, they didn't respond, they didn't do this. And again, I know this is not in the what they teach in the 1L criminal law course or criminal procedure course at the Twitter Law School, but real lawyers understand this. When you demand exculpatory evidence, there is a huge, huge distinction between making what is called a specific demand, in which you draw the specific attention of the prosecution to very specific evidence that you want, as opposed to just making a general demand for, do you have any Brady material? There are major differences in terms of the standard of review in the event there is undisclosed evidence about whether there was a reasonable possibility that it could have affected the outcome, which is a very good standard for the defense, or a reasonable probability, a much higher standard, less good for the defense. So again, let's let the Twitter lawyers be themselves. I'll be me, I'll be me, you do you, and whatever. I mean, honestly, arguing with these people. So I don't really respond to them. I mean, I just take it and laugh. I get a kick out of it.
So
But
it's better not to respond. We just have a
surprise.
laugh on the show. Let's go to this because this is somebody you go on his show. He's someone worth responding to. He's a lawyer. Law offices at Andrew Myers posted. He says Massachusetts residents generally don't care in such a liberal progressive state. You would think there was outrage after the federal indictment. There were crickets, no outrage. What do you think? Like, because this state, it's true. Like, there's been no real outrage on the Karen Reed stuff, Sandra Birchmore, the CDL licenses scandals, goes on and on. Like, there's no, even the governor, like, after today, you'd think there'd be something, but there's nothing going on. What do you think? Why is that going on, Mr. Bederow?
Again, far be it for me to try to explain the complacency with Massachusetts voters and politics. I mean, it's a long time since I've lived there, but I know the culture. I grew up in it. I understand it. Massachusetts has always had hack politics. I mean, you've had party hacks, party bosses, and just people sucking off the public, blank for a career. And there are certain areas in Massachusetts more than others where that happens. And everybody, I mean, look at Norfolk County. I mean, the district area, the different district attorney has been on the public dole, if you will, for what, 30, 40, 50 years. No jobs in the private sector. The people that work in his office, they're there a long time. Lally's been there 20 years. There's no turnover, no real turnover. They don't go into the private sector. It's a jurisdiction where the people in power generally are hacks. And there's one party. This is not a political statement about whatever your political affiliation is, but it's generally never a good thing when it's like a one party situation, because then the party hacks and bosses plant people rather than the voters. And, as far as today, just to be devil's advocate, it's an ongoing hearing. It's not over. No findings have been made. But for those of us who do this for a living and understand exactly what's happening and see what's going on, what you saw today should shock the hell out of you. and as should exactly what these same people did in Karen's case and Birchmore and whatnot. As far as, Andrew was saying, what about like the federal indictment? I took a lot of online heat for this too. The federal indictment, based on my review, and again, unlike the Twitter lawyers actually handling investigations in federal court, which is a very different game than state court. The recent federal indictment, based upon a closer review than an initial article that I read, including a very quick surrender, guilty plea, promised sentence pending court approval, which is a real thing in federal court, but I'm sure the district judge will give what was agreed upon. Every single thing you see in how that federal situation played out is suggestive of one giant nothing burger, that it's over. Because when people cooperate for a larger investigation, U.S. attorneys don't agree to time served before they do that and put it in a public filing. It would be a sealed plea. It wouldn't be released. They would talk about cooperation. There would be issues of whether you provided what's called substantial assistance under 5K 1.1 of the federal sentencing guidelines. I don't want to get too in the weeds, I understand. But that's how federal cooperation works, not arresting someone, bringing public attention to it, having them plead guilty with a waiver of indictment and a promise of time served in a week. Okay, that suggests this. We're done here.
Yeah.
Big
again, deal. We want to set an example, but we don't ruin this lady's life. She just told her friends. It wasn't nefarious. It wasn't like she was working for a cocaine ring and feeding them information. So just get it over with on that one.
Right. I don't know. I don't know obviously what's going on, but again,
but that's what it seems like.
And I get it. They really don't teach this.
Why was that controversial today? Where were you getting pushback and people were doubting that? Like, where was that coming from?
There was another one of our favorite, Twitter agitators simply posted last week that this lady had pled guilty and waived her right to indictment, which what we were led to believe was a major development. And so I commented on that and said, actually, it happens in federal court all the time that people who are interested in pleading guilty early will plead guilty to an information and waive their right to an indictment because you get more credit for responsibility, get a better deal. And I said, that is actually very common. And then what I said was, what is not very common is that they are promised a sentence of time served publicly and immediately, and then are cooperating to get others. And I just made a joke, something along the lines of, take that for what it's worth, no more, no less. But
it makes sense.
Of course,
it's like dogs too. Like, I work with dogs. You hold the carrot out in front of the dog and the treat to get their attention. It's the same thing with the feds. They're holding that carrot out in front of that witness, and they want to make sure they're gonna do what they should do till the end. So
Well, again, they don't teach this at the Twitter law school.
Yeah, they're stupid. As soon as I saw Aiden explain it, and then I saw you explain it, I got it immediately. I was like, that makes so sense.
Here's what happens when you cooperate in a federal case. You get sentenced after the cooperation.
After you cooperate. They want to review and make sure that you gave good information, you didn't lie, you testified when you were supposed to. Yeah.
The most critical component of any federal cooperator getting consideration is whether or not they gave substantial assistance. And the way that works is, in that situation, the U.S. attorney writes what's called a 5K1 letter. They write the judge a letter where they basically say, this defendant was, my God, they helped us so much, and the court has got to factor that in, even though they did something wrong. That doesn't happen.
We took down a kingpin. This is someone's been prosecuted. Someone's went to jail. Nothing like that has happened here.
So nothing like that happened. So that drew some commentary, obviously. And then there was, and we don't need to get too deep into this, but there was some really bizarre commentary from individuals, or at least one individual who apparently was perturbed that, I did not identify myself as Turtle Boy's lawyer and say this. So the point is this: I wasn't even talking about him. I mean, if I see these posts and people are being misled online that there is probably some huge federal shitstorm going on, when I'm saying, like, probably not actually. And again, you can, you be you, I'll be me. You can believe whoever you want to believe, who understands how this works. And apparently that led into this discussion that, it was wrong of me not to identify myself as a shill for Aiden. And
that was ridiculous. I said something on that. I know who she was. And I said something because, like, I felt like you didn't need to, because anyone reading that understood what you were even talking about would know that you're Aiden's lawyer. Like, it's so stupid.
Well, I mean, that's true. And I'm not going to, I have a right to comment on legal matters, and I'm not going to literally identify who I am.
Especially, like you said, it didn't even apply. It's not even about him. They're trying to make it about him, but it's not. It's not actually about him. That's the thing. Like,
my point was, my tweet was in response to the other person that we talked about earlier posting a waiver of indictment as if it meant something, like, whoa, boy, something's coming on down the line. And the answer was, sometimes, and I'm sure the other lawyers can sympathize with this, sometimes when you see people talking out of their ass who have zero clue what they're talking about or how any of this works, and they're preaching often to mindless drones who follow them because, Karen Reed bad, Turtle bad, that kind of thing, it's very hard for lawyers to at least not correct and say, listen, to the public, you just need to know something. Waiver of indictment and plead guilty on information, very common. Federal cooperator pleads guilty with a promise of time served right out of the gate, entirely uncommon. Take from what you will. And if that triggers them, whatever.
So be it. Nurse of Interest wants to see you at a Red Sox Yankees game. Do you have any plans to do that? Is that upcoming?
Yeah, I mean, they're actually possibly in a couple days. Right now, the Sox are in Philadelphia, which is not that far, and I like going there. It's a beautiful park. Going to see if I can get out there maybe in a day or two. We'll see. I like to go to games more in Fenway than New York. The new Yankee Stadium is actually terrible. Of all the modern stadiums, it's the worst of them all. I mean, it's in the Bronx. There's nothing around there. It has no environment, but the stadium is very vanilla. It's not like the old Yankee Stadium, which many Red Sox fans used to call the toilet, as you know. And it's a dump, but it was a dump with character. And to go to a lot of those games in the heyday of the late 90s and, 2003, 2004 and beyond, that was a lot of fun. But, I'd rather go to a Sox Yankees game in Boston, actually. So I'm not even sure what the schedule is, but yeah, I'll be there. I'm sure. I go every year.
Some Yankees Red Sox games, it's like an honor. Like, you just even get to get in there, because it's always like the top ticket.
I've gone to a lot over the years, and I've been to some damn good ones. I am pleased to say I went to the game in 2004 where Jason Varitek just absolutely did what he did to A-Rod. That was great to be there that day. I went in the 2004 playoffs to the not great games, but the famous Pedro Martinez "Who's Your Daddy" game. If you're a Red Sox fan, from a different generation, you'll remember that. Some of the great chilling games back then in the playoffs.
Bucky Dent. You remember Bucky Dent
on TV, but
that's like one of my earliest Red Sox memories as a kid.
You left
how mad everyone was.
You left out his middle initial, but yeah,
Bucky effing Dent, yeah.
And of course, then Aaron Boone was basically same thing all those years later.
Bill Buckner, yeah, and then Bill Buckner. Oh God.
Well,
Yeah,
listen,
it's
one
a
of the
lot different now. It's a lot different now.
one comment about Bill Buckner, which was interesting. So if you remember watching Game 4 of the 2004 World Series when it finally was happening, and it was clear. I mean, they were up 4-0 in the ninth inning, and there was no way. And it was in St. Louis. And God, I hope I'm remembering this right and not conflating. I think I'm right. There were two fans walking around with a sign that said, "We forget Bill Buckner." And, you know, it was interesting. And, Bill Buckner, you remember how he was treated. I mean, it was,
Felt horrible for
he
him
came back.
because he had almost a Hall of Fame career. He was like a really good
He had a,
player, and it was the coach's fault. The manager should have taken him out of the game. He was there for his bat, not for his. He had bad knees. He couldn't even bend over. I mean, it was just.
this is like traumatic. I can't believe we're doing this.
I
But
know.
if you,
I know.
back then that season,
Well, I feel like we can talk about it now because
do
like
it. It's okay.
we got over it. We won. We won.
They in that year, 1986, they had a formula if they were ahead late. And what you just said, Bill
Take
Buckner
them out.
had like 2 broken ankles. He couldn't
Yeah.
move. And every time they were ahead late, they would put in Dave Stapleton for defense.
Right.
That's just and Dave Stapleton couldn't hit for shit, but whatever, you're ahead. You don't need it. And for whatever reason, John McNamara, the manager at the time, just didn't do it. And, Mookie Wilson happened.
Horrible.
That was bad.
I felt. I'm glad you brought that up because I do to this day I felt so bad for him.
It's amazing.
He got a lot of shit.
He came back like 4 years later, which is insane.
Mm.
He actually came back and like played another half season or whatever it was. I think it was 1990, if I remember correctly. He came back and had like a small role, but the fact that he was willing to like sit in that dugout in that park with that fan base, which at that time, as you know, is as miserable
as
it gets. And I mean, it couldn't have been any worse after that. And he came back.
This question keeps coming up. I see on Twitter too. People want to hear more about your case with John. What's the latest on that one? You won that, but there's nothing going on. Like what's going on?
I don't know what's currently. I don't represent him anymore. Actually,
you don't. Wow.
No, I did for my God, from about 2013 or 14 until like 24, give or take. So long time. But I mean, the story is well known. He was railroaded by a prosecutor in Brooklyn who described herself as, the prosecutor who never loses. She's a big true crime voice. You can look her up yourself. The joke I always make is we don't send each other Christmas cards, but people can look it up and see who I'm talking about. She suppressed evidence, and his conviction, after many appeals, was temporarily reversed for that reason. And then the New York Court of Appeals reinstated it by finding that the evidence was suppressed, but a majority of that court held that it was not material to the outcome, which was crazy. There was a very scathing dissent. And then even after that, we found more undisclosed evidence, had a whole nother round of hearings and appeals and this, and it just went on and on for years. But as where like literally today, it's as far as I know, it's nowhere. But I have no doubt when all is said and done that he will be vindicated, and it won't be just being released on parole. He's been in prison now for 20 years. But it may even come when he's out and let go on parole. But I have no doubt that at some point he will be formally recognized as wrongfully convicted.
Do you have any final thoughts or anything else that we didn't discuss today?
No, I mean, today it was just like the Lally show, right? I mean, it's I can't believe what we saw. I mean, I truly wouldn't believe that this could be real. And I couldn't believe that these would be the same people who did what they did to Karen, who work in the same office and with the same people who are involved in all these other problem cases. I couldn't believe Lally's demeanor, his apparent lack of concern, even recognizing how awful this is. Um, I couldn't believe his testimony. I don't find it credible at all. Um, I believe, there was also that feeling in my mind. This is why it was such a shame that Karen was denied her right to a hearing pre-trial. Not that it matters now. I mean, that she won emphatically, so good for her. But she had a right to go after Lally and Proctor and demonstrate that they were up to no good in her case. And the judge never should have denied that. And I think also if that had come out earlier, like I said earlier, it could have helped this guy King today, because it could have been more fodder for cross-examination and bring more awareness to what's going on in this county. But, everything's coming out now, and I'm pretty confident that ultimately all of these bad actors and or incompetent actors in that office, whether they be the elected official, the assistant prosecutors, or the people in the state police that were involved in this, they'll all be gone, and rightfully so.
We used to take phone calls here because we could, but I've kind of transitioned out of there. But sometimes we take StreamYard calls. You want to try to take a couple calls, see what people have to say tonight?
It's summer vacation. I'm here. It's fine.
You're here. All right, cool. So I'm gonna post it in the chat right now for people. And I like this better than the phone calls, because then my phone doesn't ring all night. Once the show's over, you guys can't use the link anymore. So that's easy too. But it's first come, first serve. If you got a question for Mark, jump on quickly. Do it quickly. Yeah, I'm just thinking, other things going on too, like people want to know, do you think Bev will retire? We don't think Bev is going to retire. I heard she's going to civil court, right?
I mean, I heard the other day some people were very concerned because she was going, again, I don't understand Massachusetts judicial assignments at all. It makes no sense to me, but that she was going to Plymouth civil court, where the civil lawsuit with Karen and the O'Keefe's, and oh my God, I don't know why they switch counties as freely as they do. Doesn't make much sense to me, but again, I'm just a guest here. I don't know how the system is set up.
Yeah, and when people ask me to pin the link up top, I just did pin it, so you can get it there now. Civil case. There's like this civil lawsuit against Karen Reed happening right now. What do you know anything about that? Have you been following it? It's hard to kind of follow from where I'm
Casually,
at. I'm not
I
seeing
mean,
too
look,
much on. You think?
I think the civil lawsuit, I mean, obviously the standard of proof is less, right? We all know that. There's no reasonable doubt. It's, a much lower preponderance of the evidence standard, which some people call 50% plus one, what's more likely or whatever. But the issue in that, I mean, might the bars settle to get out? Maybe. But if Karen fights, the O'Keefe's are going to run into the same problem that the prosecution ran into, even with a lesser burden of proof. There has to be causation, right? I mean, it's a wrongful death suit. They're going to have to show that she caused John O'Keefe's death, and their theory is she caused it by the bars letting her get liquored up and driving drunk and causing his death. And the problem is, even though there's no burden of proof at the criminal trial for the defense to do anything, if you said to most people, again, putting aside Twitter trolls and all that nonsense, and said, realistically, this is something Alan said, I think, in his interview with Aiden, maybe in a different way. But if you really said, what do you think is more likely based on the evidence in this case? She did or did not hit him. Even though they had no burden of proof and only had to demonstrate reasonable doubt, I would suggest to you that the state of the evidence, the needle was tilting towards Karen's position that I didn't hit him, based upon all the engineering evidence and all the medical evidence. So I don't that's not going to change, right? I mean, so I don't know how they're ever showing that Karen caused John O'Keefe's death. So I think she's probably, even with the lesser burden of proof. Now, the other big change is she no longer is in any criminal jeopardy. So, they will be able to depose her, but, okay, I don't think that bothers them in the least. I mean,
Great. I always wonder why the O'Keefes haven't sued the homeowners. Seems like that'd be the easiest one to have a lawsuit against because they invited people over after last call after they've been
you can,
drinking,
it's a fair point. There's many ways you can look at it. To me, I mean, the larger question is, I don't know why they never challenged authority about what they were being told. I mean, it's really not my place to know. They're entitled to think what they want, and I think they're entitled to that respect. You can disagree with it, of course, but I just find it interesting that, at least by all appearances, they've never challenged what they've been told by the Norfolk DA and the other people that are supporting them, and that on some level they've aligned themselves with. Even though, some of those people, there's no controversy that they lied. I mean, Jennifer McCabe, for example, lied to the feds. That's a fact. I think it's a common sense point that she lied to many police officers and probably in the grand jury when claiming, I hit him, or claiming that she said that to all these people when it seems clear that she didn't. That Kerry Roberts lied in the state grand jury and told the feds the truth. All these other people that they're aligned with, for whatever reason, lied. That a lot of their stories about butt dials and other things don't make any sense. And I would think that you would at least be agnostic in the sense of, I'm troubled by that. I need to know why that was, and that might affect your thinking. But by all accounts, within hours of John O'Keefe's death, according to the testimony, the family was sitting down with Jen McCabe and Kerry Roberts making a timeline that, by the way, was never disclosed to the defense, but that's neither here nor there. It's weird to me, but
it is weird, the whole timeline thing.
Yeah. I mean, they've been encamped with them from the beginning, and they're entitled to do that. I just, you almost wish they at least maybe got a little more independent advice to at least satisfy themselves, what may or may not be going on. And then, they make their choice, and you have to respect it, even if you think they're wrong.
We got a couple callers here. Let's bring up the first one. If anyone wants to call in, it's pinned at the top of the chat, the StreamYard link. Brandy is the first caller. What's up, Brandy? What do you have for us tonight?
Hey, Mike. I don't know if you remember, but I talked to you like right before the verdict came out. And like we were nervous because we didn't know what it was going to be. But I just want to tell Mark and you guys that you kept us all calm, and that Mark has taken time out of his life to come on all these shows and keeping us calm. And I just loved how when they came for Paula, the juror, because she was brave enough to speak out, that Mark was right on Turtle Boy's stream seeing if she was okay and stuff like that. I just can tell you guys are true justice warriors, and I just want to thank you.
That's very kind. Thank you.
You're welcome. But that's all I wanted to say.
Thank you, Brandy. Thanks for calling. Have a great night.
You too. Thank you.
Call in again. Bye now.
Bye.
We also got Teresa. Teresa, you have a comment or a question tonight?
Yeah, I just wanted to say that Mark's right. I mean, hopefully there's going to be, I moved out of Boston area because of many different things, but one of the things is that they are corrupt. There's some good cops, believe me. I'm down in South Carolina now, but my son died of fentanyl, and the detective told me for a year that he was a high priority. He was Mass State Police detective, and that they were going to find, they were going to go through his phone, find who's, go to these stores, go to these liquor stores across the street, see who brought it in. A whole year went by, and they never had the phone. The detective, and I have all the receipts of him emailing me saying, we're on this. You know, I've been talking to a few people. Well, my ex-husband had the phone and I didn't know it for a whole year. So that, and yeah, it was very disappointing because I'm broken. You know, it happened 6
Sorry.
years ago. But the point being is tell the truth. And when I got the papers back from Mass State Police, it was low priority and it was gone like a week later. They never worked on it. So I went to the lieutenant. I went higher. I wanted to talk to his lieutenant, and they didn't. He said, "I'm sorry, but this stops here." Then I tried to call the corporal, and get into the office and say, "Listen, this corruption has to stop," because I'm a parent of somebody that you led to believe that he was going to be finding, who did this to your son. I mean, obviously, my son had an addiction, and we got him as much, care as we could. The other side of the flip of the coin is I also knew a state police officer, and he did the right thing. It was in Charlestown. I don't mind saying the detective, if I can, Mark. I'm Mike. Can I?
Mark, you have any comment on any of this?
I'm just listening.
Okay.
Oh,
mean,
it's hard.
So, anyways, I won't say the name because I've gone this far, but I will say that also the Mass State Police. I had a friend that was in the force, and he was working in town in Boston, and he reported that all the police. He worked on the water. They all traded their boat motors in, and they got all brand new boat motors. They took those boat motors and put them in their own boats at home, and and took the ones in their house and brought them back to the thing. He reported it. He was shipped 2 hours, almost 2 hour drive. They did not like that whatsoever. So they are corrupt, They got rid of him. And it was like a sweep. So as far as the state police, I've lost my respect for a lot of it. He could have just said to me, "I'm sorry, your son is gone and we can't crack the phone." I got the phone because I knew I couldn't. My former husband and I didn't have a rapport. So I said to him, "You go get that phone." This is before I said, "Or I'm going to go to your lieutenant." And he got it. And my former husband would have never given it to him if he knew. But I have a phone. I have a phone here that's cracked. It's opened with an SD card. And I'm like, that's how they do. And he said, "You can come and get it." I said, "No, you can drive it to me."
Teresa, thank you for calling. I'm sorry for your
That's
son.
okay.
We are going to move on. Thank you so much for
All right,
calling
Mark.
tonight.
Keep doing the good stuff that
Thank you,
you guys
Teresa.
do.
Let's hear from Russ. Let's keep them short, folks. Yeah, you got a comment, question, move on. We got a couple people. I don't want to keep Mark too late either. Let's just try to get Rustus up. Quick comment or question.
Yeah, I'll be very quick. By the way, you can ignore my super chat now for this. But Mark, in the King case, if the discovery evidence turns out to be immaterial, what does it mean in the end? Is there any relief for the defendants, or is it's not really mean much? And that's it. Thank you.
It's a good question. I mean, it really would have to see the motion that was made and what are they seeking. I mean, obviously, if they're seeking dismissal and serious sanctions, there is a prejudice component to this. So, you do run the risk of exposing just incredible incompetence or misconduct in the non-disclosure of evidence. But in any true egregious discovery violation, certainly in any Brady violation, which this may or may not be, I have no idea that, again, how important these warrants are or aren't. But if there's no prejudicial impact, it doesn't affect you in the eyes of the court, which is something the judge made reference to today, then there's generally no remedy, or certainly much less remedy, depending on what the nature of the motion is. I mean, like, for example, in New York, if you're making a Brady, this is anywhere, Brady has a materiality component. It's not a Brady violation technically even if the prosecutor does not disclose evidence that they were obligated to disclose, if it's not material in the sense that it might affect the outcome of the trial. So it's hard to say. But if the defense can demonstrate prejudice, that if I had these search warrants, had these affidavits earlier, i.e., years ago when they were entitled to them, I could have investigated this. And now that witness is gone. They're dead. They left. I don't know where they are. They can't be found. The witness no longer remembers things, or evidence has been destroyed. Well, now it's getting dangerous for the prosecution. Right now, they're getting into the danger zone because now the defense is starting to demonstrate that we're prejudiced by this. So, I mean, for the defense standpoint, in order for them to really get what they want, they're going to need to show prejudice. For the public standpoint, I mean, you're getting the full show either way, which is these people are a disgrace in complying with their disclosure obligations. They don't appear to understand it. They don't appear to have any system, custom, practice, training. You know, why don't they bait stamp? I mean, you know, or as Brandon used to say, bait stamp, right? No, bait stamp is literally just the numbers that you would put in the corner, which Brendan did, by the way, when he turned over discovery in this case. And you do that and you keep a chart of what everything is and what bait stamp number it is. And you make a cover sheet and you tell the defense, on this date, I'm giving you pages 1 to 2000, and they're all stamped. And you say what page is what, or what document is what. You say on the record, I'm turning it over. You give a copy to the defense. You keep a copy. You file it with the court. Where I come from, a lot of times the prosecution will have you sign for it. And you know what you have? You have a record. And the people in Norfolk County apparently don't believe in keeping records.
They don't like records.
They don't take notes. They don't remember. It's
no
just
filing.
No, it's just one giant shit show. They don't even have a process.
What happened to my notes? That was Lally today.
They have negligent supervision, and that's the kind of thing that, again, may help Karen in her 1983 case, assuming she files one.
Hi, Stephanie. You're on the show. Do you have a comment or a question for Mark Bederow tonight?
Yes, I do. I just wanted to ask just 2 quick questions. The first one is, you know, sometimes you hear that officers, when they get fired from one from where they're working at, that they can sometimes then transfer someplace else and start working. So I just wanted to know if that's something, because Proctor is looking or trying to get his job back, if he can possibly work for someone else as an officer.
I don't know what he's trying to do, but if he has people who care for him, they should probably sit him down and have a reality check about the facts of life. He's never going to be a cop again. First of all, who's hiring him? I mean, what police agency would do that without having their head examined in terms of public relations? The guy is an albatross. You know, Alan called him a cancer. You know, that might be a little strong, but whatever, you get the point. He is a disgraced state trooper who was terminated for actual bias in the case he was investigating, all other kinds of things. Everybody knows about the text messages and all that stuff. And then you saw, put all that aside, what we just said, then you saw what Lally said he did in this case, which is just ignore his constant request to disclose evidence and then turn it over piecemeal, literally in halves, if you will. So Proctor is, I would imagine, done and has a better chance of being a pizza delivery guy than a law enforcement officer at any time. I mean, he's going to have to find a new line of work that does not involve anything with public trust, because he betrayed it, certainly with Karen's situation, and it appears in this King guy and probably elsewhere, and the text messages. I mean, you could go on and on. I would imagine he's just Done.
Done. I hope so. And just the last thing really quickly is that just listening to or watching um oh, what's his name? Lally on the stand today, he just seemed like he just did not care, or just didn't even seem to bother him at all that, he has this kid, whether or not he's guilty or not, just sitting in jail for so long, and it just doesn't seem to bother him at all. And I just wonder how he doesn't seem to worry about his job or getting in trouble or anything. It just doesn't seem to bother him.
I agree. I think he has indifference. I think he has the classic shrug of the shoulders, just whatever, and is thinking about lunch. He was asked how he felt the way he was being pantsed by Proctor. Again, if you believe what he was saying, and he said frustrated. And I mean, look, there's going to be a lot more follow-up cross-examination the next time, and the lawyer is going to have a transcript, so there may be ways where she's going to dig in and go back to points. I think perhaps a minor missed opportunity today could have been drilling down on Proctor. Why were you frustrated? I mean, on Lally, why were you frustrated? Can you expand upon that? You were so frustrated that you did what, sir? That you called his boss, I mean, I think there's a lot of meat on the bone with him from today, but I agree with you. He's completely different.
Up.
Yeah, he doesn't care is the impression that he gives. He was forced to be.
Totally. I got a call from one of our moderators here, Stephanie, I believe. Is that Stephanie, our mod?
It
Hey,
is.
how you doing?
Good. I just
Good
wanted
to
to
see you
say
on
hi.
camera.
I know. I came in late, but I had caught up earlier on the whole Lally questioning whatever earlier, and I just was blown away by how he just doesn't really seem to give a shit.
Well,
The
that's a
impression.
common theme today.
Yeah, and like what will be after that, Mark? Like, will there be sanctions? Like,
There probably should be. I assume. I mean, I would be seeking sanctions. There could be sanctions from the court. There could be BBO issues with him. You never know. Which is just the disciplinary committee in Massachusetts who deals with lawyer ethics complaints. Obviously, somebody like Lally has to be acutely aware that he's all in, hitched to the Morrissey train. He would be the first one to go. If Morrissey were to lose, I can't fathom that any new DA would allow him to prosecute petty larceny cases, let alone murder cases. My gut is he's probably not long for the place. I don't know how he's even allowed at this point to handle homicide cases. There's nothing he's ever going to say or do to justify the non-disclosure of 6 search warrants in a murder case for the better part of 4 years while some dude is rotting in jail and hasn't even been found guilty yet.
is he like
Explain that.
is he getting bullied by Proctor, or does he just not
I don't know.
care?
I don't know, but one of the concerns would be because it's like one big giant fraternity house, the way they have it set up, where it's the same cops, the same lawyers, lunch buddies, drinking buddies, all that. Is it hard to say, to be forceful? It could be. I don't know what their personal relationship or dynamic is, but I found it astounding that he was just so quick to accept Proctor telling him, I'll get it to you when I get it to you. Okay, don't worry about it. And that was an acceptable answer. That's an entirely unacceptable answer. And there was one point, if I remember correctly, where he said he went to meet with him, I guess down the hall, as it were, the way they're situated. And they sat down, and Lally said, I did mention the search warrants, and he said he would get it to me. And I think, maybe another slightly missed question today that hopefully will be picked up upon in a couple of weeks was, can you explain how it is you left the office that day without the warrants? I mean, how many times can he tell you he's going to get it, and you're sitting in his office what is it? Is it in a paper file? Is it emailed? Is it electronic? Is it on a flash drive? Why didn't you have it from right away? I mean, didn't you review a copy of the warrant in the very? This is what I don't understand. Any
Yeah.
lawyer who has any intellectual curiosity in his own case, if he's not going to prepare the warrant, which makes no sense to me, I'm at least going to want to be like, well, what'd the guy say? Like, can I see it? Like, can you give me a copy? So I don't even understand for the life of me why this hearing devolves into getting it from Proctor. How do you not get it from Proctor the day the warrant is signed by the court? That makes no sense to me.
Yeah, they're not going to be able to get it. I don't know. It doesn't seem like from anybody. It just seems like Rule 14's like violations don't count against the state,
I
right?
mean, well, yeah. I mean, at least in this instance, I mean, this is as open and shut discovery violation as it gets. The real reason I think that the court is going to want to know is why. Because, I mean, obviously the sanctions get worse if it's intentional or the negligence is so outrageous and the indifference, turns into recklessness as opposed to just negligence. But the conduct itself is indefensible. I mean, they had these warrants in their possession, custody, or control from sometime in 2021. And the prosecutor is claiming I learned about it in June 2025 while the defendant is in jail. This is, I mean, I've seen some pretty ridiculous stuff over the years. Again, 90% of it in Brooklyn, New York, in the old days. This is as on the merits of the "are you kidding me" as bad as I've seen. I mean, what he tried to explain today makes zero sense. It is literally indefensible, 1,000% indefensible.
Thank you, Stephanie, for calling. We got a couple real quick because I want to try to be done around 8 o'clock here, and I know Mark's also got the Red Sox game. So let's take CR. I'm gonna, like I said, if people get mad if I drop them quickly, I'm gonna drop you quickly because this is gonna be quick calls. CR, you have a question or comment for Mark?
Yes, thanks so much for y'all's time. Mark, I'd love to get your thoughts on this. I know that Karen's trial is over and some people might be inclined to just move on, but it still really bothers me that for both of her trials that the sidebar transcripts are still sealed. And not only that, but apparently the lawyers are gagged from talking about it because when Alessi and Yannetti have done their interviews, they've said they can't talk about anything that happened at sidebar. So I think that's just a real problem for transparency. And I wonder if there's any hope that we might ever see what happened there. What do you think?
I think eventually, yes, there is no basis at all to just blanket seal something because it happened at sidebar, which again, the purpose of that is to not discuss it in front of the jury. The jury trial is over. Why they have so many sidebars is ridiculous. I imagine that a lot of the stuff discussed at sidebar could have been discussed, in court. No reason for it to be sealed or impounded, the word they use there. But there's just no reason to assume that everything that was said at the sidebars should not be part of a public trial. A trial is presumptively private. There are rules and laws in every state as to why information should not be public. I mean, this is what we were arguing in the other case in court a couple of weeks ago. But the presumption is open trial. All right. The exception ought to be we're keeping this private. The problem, what you see particularly, or what I see in Norfolk County, is that the DA's office seems to think it's the other way around, that if they say we want it to be private, it ought to be private just because we say so. And the reality is, if it embarrasses them, that's not a reason to keep it private. A reason to keep it private may be talking about a lawyer has a health issue and needs to request a scheduling issue and doesn't want to do it on the record because they're getting surgery. That's appropriate to do privately and seal. a threat to a witness or something like that, that ought to be sealed in private. But arguing over objections at the bench is not necessarily the kind of thing that ought to be private, even if the jury is not entitled to hear it. I mean, when you have a televised trial, you can kick the jury out, but that doesn't mean the lawyer should be arguing in private. So I think eventually, you know, the majority will be unsealed. I have no idea why it remains sealed today. You know, I'm sure the lawyers would love to talk about it, but if they're subject to a court order, they have to follow it, even if you disagree with it. And we have that in our own case. There's a lot of things we'd love to be talking about that should not be private as it relates to the other case, but until it's unimpounded, it's impounded. And, you know, as officers of the court, you have to respect that.
Question from CR. I appreciate that question tonight. Something different that we didn't think of to ask tonight. Lily C, do you have a question or comment for Mark?
Question. So I'm understanding that they wanting to destroy Proctor's texts. My question is it his personal texts and emails from like his phone, or is it the job related phone, or maybe both? And if they do get to destroy that, how would that affect Daddy Turtle Boy's case?
So those are very good questions. And once again, you have to remember, you know, here we are in Norfolk County where things just happen in a different way. So there apparently was a federal court order that was issued, which basically said any of the stuff that the feds gave to the Norfolk DA and for use at the trial needs to be either returned to the feds or destroyed 30 days after the verdict, which I believe would have been July 18th, Friday, right? Remarkably, nobody seemed to be aware of this except the Norfolk DA's office. So a bunch of lawyers, ourselves included, you know, obviously Proctor is of key interest to us, were notified on Thursday evening before the Friday of this issue. That's the notice that all the lawyers got, not just us. This is not a Turtle Boy thing. This is a people who are, you know, looking to get access to Proctor Communications. And, you know, there was a hearing on Friday. It was delayed a week for them to figure out what to do. Ultimately, the federal court order dictates what the DA has to do. But there's really no benefit that the DA should be getting here, because the way it works is like this. A lot of the stuff that was turned over on Proctor's personal phone, that may be an issue and go back to the feds. And then the DA now says it's no longer in our possession, custody, or control. The feds have it. We were ordered to give it back. We can't give you what we don't have, which would lead you with only one option to get that material, a TUI request. And you should expect, if that's the case, a flood of TUI requests to the feds from all these cases where people want to get access to stuff because the DA no longer has it. But what's not going to protect the DA is anything that's on business phones, emails, things of that on their server, because that is still in their possession, custody, or control. So if Proctor, Morrissey, other individuals have communications on the DA email server or on their business phones and things like that that are in their possession, custody, or control, they're still going to be obligated, if it's discoverable or exculpatory, to disclose it. So some of it may have to be gotten from the feds if it's no longer in their possession, custody, or control. But the DA's obligation to disclose what is in their possession, custody, or control is never going to change because the feds made them destroy that version. Now, the feds are not going to destroy everything. It's not going to like literally disappear. They're not going to torch the evidence. They're just saying, we don't want you to have it, meaning the DA. We gave it to you for a limited purpose and we want to get it back. So I would not assume that all of this is necessarily gone. It makes it harder to get. You know, the TUI process is a miserable process. There's no guarantee that it works. It's a case-by-case basis for each defendant in each case who may have a better claim than some others. But it does give the DA some cover for some of this material to say, don't blame us. You know, we're under a court order and we got rid of it, so you don't get it, not from us.
I've got Jay Grayson and a Cece in the green room, but you have to turn on your mics. So, all right, we got one right here. Jay Grayson, you have a comment or a question real quick? Are you there? We can't hear you. Let's try Cece. You have a comment, a question? We're not hearing you. When you want to wave, we can wave. We can't hear you. We're not hearing you. All right. Well, I want to thank everyone. Are they there? Can you hear them?
I heard the kiss, so I can hear.
You can hear them. Well, I guess they dropped off. Right.
Just
Well, we tried.
Okay.
We tried. Maybe it was my end. I don't. Sometimes I have issues. I think I got Lily C on too. We got you on earlier, right, Lily? All right. I think we got everyone. We tried. We tried our best.
Oh.
We're throwing them all back up. All right, we're gonna head out. Attorney Bederow, any last comments tonight about the Red Sox? What's the score? They're up right now.
No, they're losing 2-1 in the fifth, but you know they're facing the Phillies, who are very good. Zach Wheeler, definitely one of the best pitchers in the league. So this is not a game theoretically they're supposed to win this particular game, but we'll see.
We'll see. I want to thank you too for taking calls. I know calls sometimes can be dicey. We never know what we're gonna get, and we handle it well. I don't think anyone's mad at us.
You know, I'm happy to talk to respectable people who disagree or swat around trolls. I don't care. I mean, it is what it is. But no, those were nice calls. Nice people.
Nice. And I want to thank everyone. I'm sorry I had to cut off a couple people a little short, but you know, we want to make sure we get everyone in. I want to try to get as many as we could in, and I want to thank everyone for cooperating there. And of course, I want to thank Mark Bederow for being here again tonight. How many shows did you do today now? I know you were definitely on Nurse Kim yesterday. I know that you were on.
I was with
today?
Melanie for like 15, 20 minutes.
Okay.
You know, today, as I said to Melanie, very casual day. You know, it's kind of like summer vacation day for me. I'm not doing too much today. You know, that's the beauty of owning your own business. You can do that, especially when the weather is sunny and 87 degrees. You know, son just came home from 3 weeks yesterday. So I'm just kind of, you know, around the house today. And that's it. Although later tonight, I think I'm going to pop in on Runkle in a little bit.
He's doing a late night, is he? He always does the late night shows.
I think it starts around 8:30. I don't know the exact time, but apparently he wants to dive into Lally as well. So, you know.
Oh. And he could keep you all night. He does those he really has a stamina. I'm like,
it's
like
happened.
Runkle, like midnight, he's still going. I'm like, him and Turtle Boy. I don't know how they do the late night shows. I can't handle it.
I know. Ian is dangerous. You could go for like, it's like campfire conversation, you know, you could just go for hours, but it's like real chill. It's real fun. He's like the wittiest, funny, humorous guy around, like his delivery, brilliant lawyer, intelligent, really good war stories. I love the whole like Western Canadian out in the woods thing he's got going on. Loves dogs, which of course is always a good thing.
Yeah, Zora. You got Zora. Yes. He's great. I like Runkle.
I enjoy his stuff. So any chance that he offers, I'm like happy to do it if I can.
See, I just realized that people are telling me in the chat that he's 2 time zones earlier, so that's why he starts later. That makes sense now.
Yeah.
I never knew where he was actually.
Yeah, he's out in like Western Canada.
Oh, so he's like Alberta or
Alberta, Manitoba, Saskatchewan.
Yeah, I always assume everyone that is in Canada is like in Toronto or Montreal, you know, or maybe Vancouver, I guess. But yeah, I guess he makes sense. He's like he loves the guns. He's probably out in the middle of I don't know where'd you say, Mark?
I think he's in Alberta.
Alberta, okay.
I think so. I think somewhere, you know, maybe around Calgary or Edmonton or whatever, somewhere around there.
Very cool.
Yeah.
Well, we'll be checking you out later tonight. We'll be
Yeah, maybe
watching you on Runkle of the Bailey. For people that don't know and are looking for it on YouTube, you can find him. Just put in Runkle, Runkle, Runkle. People know how to find Runkle. Thank you, Attorney Mark Bederow, for being here. Oh, someone's showing their dog. We got to put them up.
That's fine.
Who's this?
Hi, it's Buddy and Cece. Oh my gosh, Counselor Bederow, I am so honored and humbled.
Oh,
I just, if you would please promise to be the voice of the legal expert on every channel, that would be ideal. I hope you retire soon from your practice. I think your mind is so brilliant, and I think you draw so many different people in because you're so smart, but yet you're so clear, you communicate so well, you're such an amazing leader. And Mike, I'm a huge fan of Young Jurks. So
Thank you.
Thank
and
you.
this guy is
What's the dog's name?
his name is Cassius King James, but
Aw.
you may call him Buddy.
Oh, he's cute. He looks like
Buddy,
he's very happy right now, just chilling, giving us
yeah.
the side eye.
Well, you have a side eye because I promised him any amount of minutes I give to listening to a channel of creators that I have to give to him. So he's waiting for me to
Oh, he's ready to
end
go.
this conversation, and then it will be his time. I'm so
Aw.
flattered and too shy to go on camera, but thank you for everything. It's been like a master class for me.
Thank you so much for calling in.
Oh, thank you. I
Yep.
support
Have
you
a
both.
great
Thank
night,
you.
Cece.
Beautiful. Thanks again, Mike. Bye.
Thank you.
Care.
Cute dog. It's a
That's
cute dog. I was having trouble hearing her. It seemed a little distorted, but I like the dog. It looks like an Airedale. I don't know.
Yeah, that dog was cute and like the dog days of summer, just chilling. It's what they do. I've got Lola's right here, but she's passed out under the table, keeping nice and soft. I can put my feet on her and she doesn't care.
Yeah, there you go. I heard Buddy Cassius. I think she said Cassius Clay. Actually, I think
I heard
that's that's the only thing I could hear there from her call. It's funny, but very cute dog.
Yes, that was a cute dog. And I don't usually like little dogs. I don't dislike them, but my dogs are always like bigger on the bigger
Big
side.
dog. Yeah, you like the mid-size to big.
Yeah, like 70, 75, not like ginormous.
Yeah, not the big. Yeah,
No Great Danes or anything. Labs and like.
I love labs. Labs are the best. They're so fun. Just chill dogs. Just normal dogs.
You should have somebody I think just said it too. You should one day have like a dog party where
Oh, we should. We kind of did that. I think it was a nurse Kim that did that. Remember we did that pet fundraiser with her.
Yeah, maybe you're right. Maybe that wasn't an original.
That was
idea.
fun though. We all brought up our little dogs and kitties, and Meredith I think had cats, and some of us had our dogs. I know the Glare had Clubber.
Right, and then he got another one. Doesn't he have two now?
Yeah, he did. Yeah, he's got two now, I think. Yeah. It's funny because sometimes I have different dogs. Like upstairs, we got a whole dog party going on. We got it's that time of year where people travel, so we have a lot of dogs visiting. Attorney Bederow, I want to thank you again for being here so much tonight and spending time. We'll be looking for you on the Runkle of the Bailey tonight as well. Anything else coming up that you know of?
No, I don't have anything else planned. Hopefully, it won't be all night, but you never know, right? It could be one of those late nights.
Late night.
Past my
bedtime.
bedtime.
What about I guess the last thing is Aiden's next court date. Do you know what it is offhand?
I do, only because it's a big deal because things are not resolved from the last date. So the next court date is August 13th. I will not be there in person, but should be a very active participant on Zoom because there's a lot to do and say that I'll have a role in, assuming I can schedule everything to do it. So I would imagine that I'll put on a half a suit on that day from parts unknown and participate. But I will
Excellent.
not be. I will not be
You
in
not
Mass.
be in person.
No, not this. It's vacation time for me.
All right, we'll be looking for you August 13th. What day is of the week? Is that's a Monday, I think, isn't it? If I look when I
It is.
believe when I looked at it last, I want to look.
That's a
No, it's
Wednesday.
not a Wednesday. It's a Wednesday. Yeah,
Yeah, that's a Wednesday. Yep.
Wednesday, August 13th.
Yep. So
All right, well, we're looking forward to that. Wednesday, August 13th. Do you know if that's like 9 a.m.? I'm guessing that's a 9 a.m.
now it's an afternoon appearance, I believe. Actually,
It's a noon. It's a noon late appearance. Okay.
Let me just check the calendar. August 13th is 2 p.m.
Oh, 2 p.m.
Yep. Yep. 2 p.m.
I'm trying to decide if I'm going to go to that one. Maybe we'll see.
Sure, but yeah, I mean, look, people should go. As we have a lot of support last time. That was great to see.
Yeah, it was huge.
Yeah.
I hope people show up. Again, I want to thank you so much for being here, and we'll look for you on Runkle of the Bailey coming up tonight as well.
Okay. We'll
Have a
talk
great
to you.
night.
Nice seeing you
You
again.
too.
Bye.
Bye now. That was attorney Mark Bederow. I want to thank him for being here again. Like he's always. Oh, I threw that up. I didn't even mean to. Some people were complaining about the super chats tonight. I think some of you might be new, but we posted up that attorney Bederow doesn't like the super chats during the shows that he goes on. I agree with him. I think it gets to be too much, especially when he's on the show. If we start asking questions based on super chats, then I get all stressed out, and we get hundreds and hundreds of them. So we let people ask questions for free here, and it's fun, and I like to do it that way. I saw a couple people complaining tonight. I'm sorry. That's just the way that we're doing it now. I'm going to read a couple of them now. Susie from San Francisco said two of my three favorite M's. Oh, speaking of that, I'm trying to get I'm going to try to get Mazda back on the show this week as well. So hopefully you'll have your other M you're looking forward to. Jen O, been a member for 14 months. She's one of our moderators here. She's fabulous. She said Lally got snippy when the questions got uncomfy. Thank you so much, Jen O. Thank you for everything you do here. And Sarah and Stephanie and MJ and Scott McGinnis are 5 mods. I want to thank them so much for being the mod team. I also want to announce on Wednesday night, we have a big show. Make sure you check it out. We're going to have Brad Bradley. He is the brother that you may have seen on the Netflix series that's airing right now. Amy Bradley is missing. It's about a woman who went missing decades ago on a cruise ship from Aruba to Curacao. And the family's been looking for her ever since. And it's a 3-part series on Netflix right now that people may have seen. The brother is going to be here, I believe, at 6 p.m. on Wednesday night. I'm looking forward to the interview. We're going to discuss the Netflix series and also some things that didn't make the cut in the Netflix series, like the fact that she has a boyfriend. She had a boyfriend that wasn't mentioned in the movie. There's also Scientology angle that hasn't been really discussed much, and we're going to discuss that. Brad was there on the cruise. He was hanging out with his sister the night it happened. I'm looking forward to speaking to Brad. It's affected his life. You could, if you watch the Netflix series, you can see that he talks about how it's affected his life. I'm looking forward to that interview on Wednesday night. On Thursday night, I have Toby here. Toby is the guy that we featured recently. He got raided. His shop got raided by Brian Higgins and the ATF. We're going to have him here on Thursday night. So Wednesday night, Brad Bradley. Thursday night, Toby, the gentleman that got raided by the ATF, Brian Higgins. He's going to tell his story again. I'm going to interview him on Thursday night here. And on Saturday night, we have another DA candidate, Norfolk County. He's coming in, James Bearcat. He's another candidate for district attorney running against Michael Morrissey. We're going to have him here on Saturday night. So there's a lot of shows upcoming. I hope people subscribe, follow, and check back for those shows upcoming. I want to thank everyone who's been watching and checking us out tonight. And the super chats, I want to thank Lisa G, who's been a member for 2 months. Thank you so much, Lisa G. Also want to thank Janice Vetter. She said Lally is Ior. Oh, maybe. Yeah, he definitely sounds like it. He's got the same voice. Thank you, Janice. Darcy says, vote Juna Perkins, DA, Norfolk County. I guess Darcy's got her favorite already in the race. I do like Juna Perkins, but I'm also interested in hearing from some of the other candidates. Jim Bearcat is going to be here on Saturday night. Also, Rustus Android said $5. It says, if the discovery turns out to be non-material, is there any relief possible for the defendant? Sure. Deborah Clare says people put too much trust in DA and law enforcement. True. Blind eye. Absolutely, that is true. A lot of people put a lot of trust in law enforcement, and unfortunately, they get let down oftentimes. Janice also says, I pray the FBI is watching. Thank you so much, Janice, for the $1.99. Rodus Android also said $5. It said super chats read at the end, but you will pull up tons of off-topic normal chats throughout the stream. I'm not getting the logic. I think I just explained it. If you were around when we used to do super chats like that, when Bederow would come on, we'd get like 150 of them, and it would get ridiculous because some of them weren't good questions to ask, and sometimes they were silly, and sometimes it would be frustrating for me because I'm trying to read them all, and there's no way I'm going to be reading them all, and people get mad. They get mad when their question doesn't get asked and they get paid money. So when Bederow suggested that he didn't want to do shows with super chats, I was like, yeah, I agree. I feel like actually the same way. So I mean, that's basically what we do with him. Even with other guests with super chats, I still take them. Sometimes I'll post them when the guest is here. But if it's not a good question, and sometimes it just interrupts the flow, I got to say. But I like kind of picking out the questions that are free because it's kind of like a surprise for people. If their question actually does come up, they're excited. They don't feel like they're owed the question. So I kind of like the feeling of it better, and I feel like it gives me more of a input if I want to ask the question. If like you said, some of the stuff was off topic tonight. I think that's good because sometimes I feel like we're talking about the same shit over and over and over again. And that's why I like some of the phone calls tonight too, is that some of the questions were actually really good that haven't been asked. So that's kind of the reason. I think I explained that. Janice is a good comment. She said, did Prusty plead guilty today? Yes, she did. That's a funny thing. Mark was saying, you can compare me to her, and Mark didn't plead guilty today. She did plead guilty. It was a lesser charge. It wasn't the felony, but still, she did plead guilty today. And Mark Bederow did not plead guilty today. KP did for sure. Alicia said $9.99 and said, Bederow, you must come to Alberta, and I take you inside of all the BB houses and introduce you to the producer of BCS. Huh. West Virginia country guy sent $5 and says, is it possible that some of the supposed warrants don't exist, weren't actually authorized, etc.? I mean, that is the question, right? Apparently they do exist because I believe he did get them eventually. OnlyFan gifted 1 Young Jurks membership. But exactly, like, why would it take so long? None of it makes sense. So who knows? Who the hell knows? Qbert said $4.99, says, ma'am, this is a Red Sox tweet. Still cracks me up. And thank you for being so polite to that gal, Mark. Thanks, Mike, for always being here for us. Thank you so much. Stephanie, thank you, Qbart. Stephanie also gifted 10 Young Jurks memberships tonight. She also called in. Thank you for the call, Stephanie. And thank you, Paul Youngs, who also gifted a Young Jurks membership. Thank you so much for the donations tonight. Also, I got some Venmos. I know there was one earlier today when we were streaming, so I want to thank the Venmo that came in. Let me just get my account up here. 1 second. All right, a couple Venmos. Barbara M sent $10 tonight. She said gift. Thank you so much, Barbara. That was actually earlier today, I believe. Was that earlier today? I can't tell. That's not telling me, but thank you so much, Barbara. Also, Deborah S sent $20 the other night. I didn't get to thank her on the 17th, so I want to thank her now. Thank you so much, Deborah S. And I think it was the Cash App that I got mixed up on, the ones that came in. Yes, Tiffany S sent some money earlier today on the Cash App. She actually said it was thank you for your work legalizing cannabis specifically. I guess she's just discovering some of the work I did for that issue a while back, actually. But yes, I appreciate it. If you like that stuff, you should probably thank me for it. It's true. It's true. If you don't like it, you can blame me for it. How's that? All right. I want to thank everyone who's been watching, supporting, checking us out tonight. If you can subscribe, we're pretty close to 60,000 subs. We're at 59,000 and change. So let's try to get us there tonight or this week. I'd love to get to 60,000. I want to get to 100. I want one of those plaques. I don't know why it makes a difference to me, but it does. I want to get one of the plaques in the studio. It's a weird thing, you know? So I want to thank everyone who subscribes and follows us and supports us. We're also going to be streaming on Thursday morning. There's a post-commission hearing for what's his name? Oh, I forgot his name. Joshua Heel, I believe is his name. He's the dog officer. We're gonna cover that tomorrow, Thursday as well. Not tomorrow, Thursday. So there's a lot coming up this week. I've been kind of taking nights off and days off, coming back with some shows this week. It's time to get back and do it. The Karen Reed break is over. All right, what I'm going to do to close out the show tonight is I'm just going to replay this. I want to replay the video from earlier today for people that didn't get to see it. This is the evidentiary hearing when Adam Lally was on the stand today. This was something to see. We're going to watch this on the way out. And thank you everyone for being here. Thank you to my mod team. And hopefully we'll see you on Wednesday night. I might even do a little show tomorrow night. There's going to be a select board hearing. I always like to broadcast the public comment. So I may do a little quick show tomorrow night as well. Tuesday night won't be anything big. But Wednesday night's going to be the big show. Make sure you check that out with Ben Bradley. His sister has been missing and possibly abducted from a cruise ship decades ago. We're going to be talking to him on Wednesday night.
Always new information that you're getting from the state police?
I think it would vary. I think there were certainly items that I probably had to ask for more than once, but there were definitely items that I had asked for and was provided promptly, and then moved on from there to either additional information or that avenue was complete.
So do you keep records of, I asked for search warrants, I asked for crime lab stuff, I asked for witness statements? Do you keep records when you receive that information to be able to check off to say, I got these things, they're no longer outstanding, and the rest of this is?
I mean, I keep records in the sense of a list of items I'm looking for. And obviously when I receive something, then yeah, that would get checked off the list as far as I'm not looking for that anymore because I have it.
Okay. So if you got a set of grand jury minutes from a witness that you know testified in front of the grand jury, you'd check that off your list?
Well, as far as yes, I mean, I was at the grand jury, so I know who testified at the grand jury. But as far as receiving the minutes, yes, I'm aware of the dates. And when I receive the minutes, then that would check that off the list.
I missed, I think, a question and answer, one question earlier. I think the question was, do you keep records of what you requested? What was your answer to that question?
So records, as far as what was requested, I would always have, at least in some form, some sort of running list of items I was looking for. And then if I received an item, then that would be something that would be off the list. Now that list would be obviously added to as information develops, and there might be additional items that I'm looking for.
And presumably because it's on the list, you've made the request?
Yes.
Okay.
And so you'd have whatever's on the list, you'd have emails requesting that information. Is that right?
Yes.
Okay. And then if they emailed back, you'd have checks off of your list that you got whatever it was. That, you know, maybe you were asking for 10 things and you got 5. You'd check those 5 things off your list. Is that right?
Yes.
Is there any other mechanism you used to document what you got from, just right now we're talking about the state police, Trooper Tully and Trooper Proctor?
I'm sorry, any other mechanism of doing what again?
Keeping track of what they're producing for you. Is it all just emails and check marks on a list? Or is there some other way that you keep track as well?
No, I mean, it would be something that I would have a list of items that are outstanding that would be, you know, followed up on if they hadn't been received at that point, and then I would follow up with whoever the appropriate person was to get copies of those.
And these lists remain in the file? Your lists with the check marks remain in the file?
To the best of my knowledge, yes.
Okay. And have you reviewed any of them before you testified here today?
No.
Okay. Is there a reason you didn't review the file before you testified here today?
I don't have the file.
You work for the DA's office, right?
I do.
And it's in the DA's office, right?
Yes.
And you knew you were going to be asked questions about this case, right?
Yes.
And you didn't do anything to educate yourself about what you did initially on the case?
Objection. This is her witness.
Well, I'm not sure I agree with that as an objection, but I'm going to sustain the objection as to the relevance. He did not review the file. Next question.
So what did you review in preparation for your testimony here today?
I reviewed portions of the file. I reviewed some of the items that have been produced by ADA Hickman. I reviewed search warrants. I reviewed police reports. I reviewed, you were asking specifically as far as checklists or notations. I didn't review those, but I did review, I have portions of the file. I have access to the file, and I did review portions of the file.
Okay. So you did review portions of the file?
Yes. Oh, yes.
You just didn't review your checklist?
No.
Okay. Now, in terms of the Milton Police Department, do you also have emails going back and forth to the Milton Police Department asking for certain documents?
Yes.
And who in the police, would that be Lieutenant Collins?
Yes.
Anyone else in the Milton Police Department were you looking for documents from?
On this case, I don't believe so, no.
And did you keep the same type of list that you kept for the state police of outstanding things that you were looking for the Milton Police Department?
Yes.
And what did you get back from the Milton Police Department? Do you remember?
Items of similar nature that they had access to, as far as police reports, photographs. I don't believe Milton did any of the search warrants in this case, but other items of discovery, video that they recovered, that there's a litany of different items.
A litany of different items? Did you
Yes.
say? Okay. And those would all be memorialized by email? Is that how you did it?
Yes, that's, I think, what Mr. McGee attached as Exhibit 1. It's about 137 pages.
Of emails back and forth between the Milton Police Department and you?
Correct.
And so at what point do you know that you have all of, so other than, strike that, Milton Police, State Police, any other person or entity that you sought information for in this case?
Certainly.
I'm sorry?
Yes.
Who's that?
Be the Officer of the Chief Medical Examiner, be the State Police Crime Lab. There were some items that were outsourced to Bodie Technology Lab in Lorton, Virginia, where they did some additional forensic testing pursuant to DNA. They have different methods that our lab does not. Milton Fire Department, I believe Fallon paramedics were involved in the transport of the victim, Mr. Simmons. That's all I can think of at this point.
Okay. And would you communicate with those agencies the same way you communicated with the State Police and the Milton Police via email?
For the most part, could have been a phone call on some of those
All right, so let's stop
issues.
there. if there was a phone call, how did you memorialize what you requested and what they said in a phone call?
Notes.
You have individual notes.
Yes.
And where would those notes be right now?
In the file.
Okay. So do you keep like a running page of all the notes that you've taken in the case with communications that you had with all of the other entities and officers in state police in this case?
Not all in one location, but it would be sort of divided up by different entities as far as what I was requesting from that specific entity and what I was looking for, what I was still waiting for, what was still outstanding, things of that nature. Okay.
So what happens when you ask for something, let's just say from the state police, and they don't give it to you? What's the next thing you do?
The next thing I do would be to ask for it again.
Okay. How many times do you ask for it before you have a meeting with the state police to look at their file?
Objection. The biggest objection I have here is that we're not speaking about any individual document, any individual date. Vague questions about
this is general practice, generally Mr. Lally's practice. I think part of the issue here is we don't have very specific items that are being referred to. Right. But I think I'm going to overrule the objection and give Attorney Scapiccio a little bit of leeway here in terms of general practice.
So in general, how many times do you email for the same document before you go to the state police and start to have a sit down with them?
I think it varies. I think it would be depending on a lot of different factors as far as what the item is, what the explanation is for why I don't have it yet, whether it's not available or whether it's something that they're currently working on, or if it's something that I know has been completed and I've asked for it multiple times and I still don't have it. I'm not saying that even happened in this case, but if in a general practice, if that were something that were going on, then yes, I would want to sit down with somebody and figure out exactly what's going on. Okay.
So let me ask specific questions about this case. When you reached out, let's start with Trooper Proctor. In this case, looking for information, and there were emails back and forth. Were there any occasions where you did not get the documents or the information that you were seeking from Trooper Proctor?
I don't recall anything specific other than if it was a situation where I'm looking for a report about something and that report hasn't been completed yet, or that item hasn't been obtained yet for whatever reason. But I don't recall in this case ever asking for something and just not getting it.
Do you remember asking Trooper Proctor for the search warrants that he did in this case?
Yes.
And the affidavits accompanying the search warrants?
Yes.
And did he provide them to you?
What I received was a partial affidavit for search warrants.
Did he provide them to you, yes or no?
Some.
How many search warrants do you recall there being in the King Gardner case?
In 2021 or beyond?
Let's start with 2021. How many search warrants? You guys search warrants?
6.
6. Did he, when you asked, and he signed all 6 search warrants, is that fair to say?
That's my understanding, yes.
Okay. And so when did you ask Trooper Proctor for the search warrant?
In July or August of 2021 when they were filed for.
Okay. And when did you get all 6 search warrants from Trooper Proctor?
I didn't get all 6 search warrants from Trooper Proctor.
You did not?
I did not.
Okay. So did you get 1 search warrant from him?
From him specifically, I received a portion of the affidavit for search warrant 306 and the entire affidavit for search warrant 348.
Okay, so you got portions of 2 search warrants, and you knew there were 6 search warrants, is that right?
Yes.
Did you make notes somewhere in your file? Geez, I asked Trooper Proctor for these 6 search warrants. You haven't given them to me yet?
I believe, yes.
Okay, those notes are in your file?
I believe so, yes.
Okay. And then when you didn't get search warrants from Trooper Proctor, did you meet with him?
Yes, I mean, specific to that, I don't recall any specific meeting related to search warrants, but we did meet several times in relation to this investigation in this case.
But you understand that search warrants are Rule 14 automatic discovery, right? and you knew there were 6 search warrants, right?
I did.
And so when do you realize that you don't have all 6 search warrants? How long into the process? Do you know right away you don't have them all, or do you not know for a long time you don't have them all?
I don't think I realized at that time that I didn't have them all.
So then I guess I'm confused about how your system works. You said you had a system where if you asked for something and you didn't get it, you would then follow up with the police officer asking again and again. Did you do that with Trooper Proctor in this case with the 6 search warrants?
Yes, I believe so.
How many times did you email Trooper Proctor asking for the 6 search warrants?
I don't know.
More than 10?
I don't believe so, no.
Okay. How far in between each email? Did you wait a month and email him again? Did you wait a week? Did you wait a day? How long in between your requests to Trooper Proctor to produce the 6 search warrants in this case?
I don't know.
You don't?
No.
Did you review your emails before you came here today?
Some of them, yes.
Did you see any emails to and from Trooper Proctor regarding the search warrants?
Yes.
How many did you see?
I don't recall.
More than 5?
Yes.
More than 10?
I don't know.
What are the dates of the first time you asked Trooper Proctor for the search warrant?
Specific date, I don't know.
How long before the next time you asked him for 6 search warrants?
Specifically, I don't know.
Was it months or weeks?
Weeks.
Weeks later. Okay,
Yes.
so that's 2 times you asked him. What about the third time? How much time went by?
I don't know.
Months or weeks?
I don't know.
What about the fourth time?
Again, I don't know how many times and I don't know specific dates.
So I guess my question is, how does your system work if you're not getting the discovery that you're asking a police officer for, and you're asked for it, let's just say 5 times? What do? Do you go to the office and you sit down and say, give me these search warrants, I have to turn them over?
Yes.
You did?
Yes.
Did you do that in this case?
Yes.
You go to Trooper Proctor and say, give me the search warrants because I have to turn them over.
Yes.
When did you do that?
Sometime prior to the defendant's arraignment in December of 21.
November of 21, did you say?
December of 21.
December of 21. So when you get to his office, do you go there or do you tell him to come to your office? I don't know how that works.
Either way, I don't
Remember how you met about the search warrants the first time?
In
other words, did he come to you or you go to him?
I don't know.
Okay. So you have a sit down.
Yes.
And you ask him for the 6 search warrants, and what does he say?
You will get them to me.
He will get them to you.
Yes.
Okay. If you tell him I have an obligation to turn this over because it's Rule 14 discovery, I need it right away, I've asked for it 5 times, what's the deal?
Those specific words, no, but the gist, yes.
Well, tell me what you said specifically.
I don't know.
Well, give me a best estimate of what you said to Trooper Proctor after you asked 5 times the search warrants that he didn't turn over.
Sustained.
So did you keep any notes of your conversations with Trooper Proctor when you were asking for these 6 search warrants that he didn't give you?
No.
Why not?
It was something that I knew that was outstanding. It was something that I had asked for in written form numerous times. I didn't feel the need to write a note that I asked for it again.
So that's the first sit down. Did you send emails after the first sit down saying, hey, you promised me you're going to send these 6 search warrants, I still don't have it?
Objection, assuming facts.
Overruled.
I'm sorry, could you repeat the
Did you
question?
send another email to Trooper Proctor after you had the sit down at sometime in December of 2021 saying, hey, you still didn't send those 6 search warrants, can you send them over?
Yes.
How far after Mr. King's arraignment in December of 2021 did you send that email to Trooper Proctor?
I don't know.
Was it a year?
I don't think so, no.
What do you think? What's your best estimate of when you sent that email after you sat down with Trooper Proctor?
I would say probably a few months later.
All right. A few months.
Yes.
So February, March of 2022, is that what you're thinking?
I don't recall specifically.
So when you're in this room with Trooper Proctor asking about the 6 search warrants, do you ask him for his file? Like, give me your whole file so I can go through it and figure out what's in it?
No.
Why not? You're there. there's outstanding discovery, you have the obligation, not the police officer. Why don't you ask?
I entrusted that whatever discovery I was requesting, I would get at some point in a timely fashion and then turn it over.
But you didn't get it. You asked for it 5 times. You didn't get it. You had to go see him. You have him right there now, and you still don't say, give me your file? Let me go through it?
No, I did not.
And when he says you'll get the search warrants, I'll send them to you. Did he have them? Did he have copies of the search warrants? He just wasn't giving them to you?
That I don't know. You'd have to ask him.
Well, you don't get the search warrants in any event after that sit down, and you send another email. What's Trooper Proctor's response to that email?
Again, I don't know that I sent another email, but I know that there were subsequent conversations about it. Whether it was what format it was in, I don't know.
Okay, and at this point, you have to be getting a little upset with Trooper Proctor that you're asking for information that he's not giving you, right?
Objection. Overruled.
I'm sorry, your question again?
You have to be getting a little upset at Trooper Proctor that you're asking him for information that he's not giving you, right?
I'd say upset, frustrated probably.
I'm sorry?
Frustrated probably.
Oh. Judge, can we approach sidebar just briefly? I know.
Sure.
Search warrants was marked as grand jury exhibits 33, 34, and 35.
Right, but not the search warrant.
Correct. Well, no, actually, I'm sorry.
Information in front of the grand jury about 6 search warrants that you hadn't seen, and you put returns or information that had been returned in front of the grand jury on search warrants you had never seen.
So with
Answer that
the,
question.
and I'm trying to, so
Okay.
with regard to those 3 search warrants, that was 306, 307, and 329, which were the call detail records for your client, the victim, Mr. Simmons, and Mr. Jeanette. The materials all that came back from the cell phone providers also contained a copy of the warrant, as well as the addendum to the warrant, which was then also provided to you and Ms. Costa in discovery.
But not the warrants themselves.
No, the warrants themselves and the addendums, not the application and not the affidavit.
Right, so you understand that in order to make a determination as to whether or not you're going to suppress certain information, you actually need what you asked for and what you, in the affidavit that told the clerk magistrate why you had probable cause, right?
Objection.
I can take judicial notice of that, and I'm sure Mr. Lally knows that.
Okay, so you get in front of the grand jury. When do you present this case to the grand jury?
Began in July of 2021. That grand jury sat in July, August, and September. The presentation had not been completed at that point, so there was a motion to extend the grand jury. And I believe there was one subsequent date that we went before them on November 19th, 2021.
November what?
19th, 2021, that's when indictments were returned.
In 2021?
Correct.
Okay. So at some point when Mr. King is arraigned, you understand at that point, Rule 14 kicks in, right?
Yes, I mean, I'm thinking,
right?
I'm thinking about Rule 14 well before that.
Okay. And you know, when you arraign Mr. King, you still don't have the search warrant. You have another conversation with Trooper Proctor about, hey, where are these search warrants? I have to turn them over.
I'm sure I did.
And do you know when that would have been?
I don't.
Okay. And then remember at some point in December of 2021, receiving a discovery notice from me. Hey, Professor Wittenschranz,
Yes.
this is just my discovery notice.
That a discovery motion, or what is
Motion,
that?
I'm sorry, motion, Judge.
Yes.
Okay. And do you remember, after having filed this motion, you asked the time to go through and make sure that you can comply with all the requests, right?
Yes.
And you didn't have any specific objections to anything that I was asking for, right?
At that time, no.
Okay. May I approach the witness, Your Honor?
Yes.
Sorry, Judge.
Is that an exhibit? Is that a docket entry?
It is a docket entry, Judge.
Do you know what it is?
I think it
Or we can mark that just so that there's a record of what you're showing the witness?
has my writing on it, Judge. So
All right,
I wouldn't
so-
mark it. But I'll do it after the hearing. I'll find the exhibit and I'll make a clean copy and send it to the court, Judge. So once you get the discovery notice, you know for sure that there are certain categories of information that we're looking for, right?
Yes.
And number one is all automatic mandatory discovery under Rule 14, right?
Correct.
Would you consider those search warrants automatic mandatory discovery under Rule 14? Okay. And we were looking for any and all statements of witnesses, is that right?
Yes.
And we were looking for all exculpatory information, whether
The
tangible.
document speaks for itself.
Okay, that's fine, Judge. So after I filed this motion to December of 2021, you have another conversation with Trooper Proctor saying, give me the 6 search warrants.
I'm sure I did. My general practice is if there is any discovery motion that's filed by counsel, what I'll do is I'll send that to the appropriate police personnel as far as making requests and making sure that they're apprised of what's been at least asked for.
And did you do that in this case? Did you send my motion for discovery to Trooper Proctor, to the Milton Police, to the crime lab, to the medical examiner's office? Did you send it to all of those entities?
Every motion that you filed, yes.
Okay. And then what do you do to follow up with each of those entities? Let's start with the state police. They get a copy of my discovery motion. You're looking for all of the evidence that they have, and specifically these 6 search warrants that, for whatever reason, Trooper Proctor hasn't given you. When you follow up, how long does it take you to follow up from the time that you give them the motion until you get an answer from them?
Specifically, I don't know. Typically, I would give it a couple of weeks or so.
And after a couple, and in this case, did you give it a couple of weeks, you think?
Probably.
Okay. And then what happens?
And then I'll follow up again.
When you say follow up, do you send another email, or do you get in your car and drive down there and say, we got to end this, give me this stuff?
I email or a phone call.
Okay. And so did you email or phone call, or make a phone call to Trooper Proctor in this case?
I'm sure I did.
And what was his response
I don't
when you
recall.
asked for the 6 search warrants?
I don't recall.
Well, do you have any notes of your conversation with him? Remember you taking notes?
I don't believe so, no.
Is there a reason that you didn't take notes when you spoke to Trooper Proctor after these search warrants had become an issue? That you wouldn't take notes of what Trooper Proctor told you about the search warrants?
So you're asking me about a conversation that I don't recall specifically when it happened or exactly what was said. So whether or not I took notes for that conversation, I don't know. What I would do typically in my general practice is to follow up with whoever I had outstanding discovery requests in relation to try to get whatever information that I was seeking.
Okay, and so did you follow up with Trooper Proctor about the 6 search warrants?
I'm sure I did, amongst probably a number of other items.
Okay, and then you knew this case was going in for another date on discovery, right?
Yes.
And you knew you'd have to answer to the court what you've provided and what's outstanding. Isn't that typically how it goes on discovery dates?
Yes.
Did you ever tell the court, geez, I got to have these 6 search warrants that Trooper Proctor has, I can't get my hands on them? Can you issue an order, or can you help me out here?
Did I do that? No.
So when you went to court, do you remember representing to the court that discovery was ongoing and that you were producing as much information as you could? Remember that?
Typically, that's what I would say if that was the case, yes.
Okay. But you knew when you represented that to the court that you didn't have the search warrants, right?
Yes.
So what was your plan? How are you going to get them?
As I stated, what my practice would be if there was some outstanding item of discovery, I would request it and follow up if I hadn't received it.
But you did that. You requested it 5 times. You went to see him. Then you got my discovery motion. You sent that to him. You waited another month. And then what happened?
I don't recall.
Well, Don't you tell him, get me these things now, I'm coming down your office?
Objection.
Overruled.
Did I ever tell him that? No.
Okay. So what do you do when he's not complying with your request? Let me ask you this. What's the policy in the office of the district attorney's office in Norfolk County when a state trooper is not complying with a request for discovery?
Objection.
Overruled if there is a policy.
What's the policy?
I don't know any specific policy related to that.
Okay. So do you go to your supervisor then and say, hey, I've asked Trooper Proctor 5, 6, 7 times for these search warrants. I've been down to see him in person at least once. He's not giving them to me. What do I do?
No.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Objection.
Overruled.
Not that I recall, no.
Okay.
Your Honor, may I be heard on one slight issue? The discovery that the discovery request the counsel is speaking to, I don't believe that it was ever docketed. I don't have a copy of it. I've never seen it. So
the motion, the motion?
The motion for discovery was filed. He got it.
It may not have reached the docket.
I want to make sure that you see it, though. Let's make sure you...
Speaking about it a lot here.
No.
I've never seen it.
Attorney Scapiccio, can you just give it to Mr. McGee for a second?
Sure. You think it would be in the file?
I would think it would be in the file. Is that a clean copy?
That is a clean copy, Judge.
Can we mark that? Should we mark it?
It's unsigned, and it's probably, I don't know if it's a draft or a...
Oh, the non-signed, all right, so let me get you a signed copy, Judge.
Yeah, I don't know what was...
The bottom line is, this witness said he received it, Judge. I know I wouldn't have not filed it. We talked about it in the hearing. And I think there is a transcript, Judge, of a hearing where we talked about the discovery motion, the court had it.
All right, we'll figure that out.
You guys...
We do have ADA Hickman did have a copy.
You do have a copy?
I never saw it on the docket. I was working right off the docket.
Okay.
So,
and just so the record is clear, we have marked it. You want it marked as Exhibit 1 in this hearing?
yes, Judge.
Sure.
All right.
Get you a signed copy, apparently.
All right. That will be Exhibit 1.
Thank you. I'd also, at some point, Judge, like to mark the pretrial conference report in this case.
Thank you.
So this had never happened to you before, Attorney Lally, and you didn't go to Lynn Beelan, who was your supervisor, and ask her what to do. What was your plan? How were you going to solve it?
I don't recall specifically having a plan. If there were a situation where I was asking a trooper or a case officer for something and I had not yet received it, I might get that person's supervisor involved as far as saying I've asked for this a few times, I don't have it.
Okay, let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
Yes.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor?
I don't know if I did or I didn't.
But as you sit here today, you don't remember going to a supervisor, is that right?
I know that there were a number of meetings in relation to discovery that Lieutenant Tully was present for, along with Trooper Proctor, but going specifically to his office to demand 6 search warrants, I don't recall that.
Okay. So how much time goes by before you ask for the search warrants again?
I don't know.
Is it a year?
I don't know.
During the time period, it's fair to say that we were appearing in court every couple of months on discovery, right?
Yes.
Did you ever notify the court on any of those court appearances that you were having trouble getting custody of the 6 search warrants that were issued in this case?
No.
Okay. Now, you talked about having meetings, discovery meetings. Tell us what those are.
At various points, probably more towards the early stages, or if there's something that's significant that comes up, it would be just a meeting in relation to, this is the discovery that's outstanding, this is what I'm looking for, what's the ETA on this, when should I expect to receive this?
And are those meetings in person or on the phone?
Typically in person.
And do they take place at the DA's office or at the state police?
Well, I mean, in this specific instance, the state police is attached to the DA's office, so it's the same building. So whether it was my end of the hall or their end of the hall, I don't know.
Okay. And do you remember discussing the search warrants and the outstanding nature of the search warrants at the first discovery meeting?
Yes.
And what was the response?
That the search warrants are still ongoing, as some of those search warrants were not just July. I believe it continued into probably September of 2021 as far as the last of the search warrants. I could be off on those dates, but
so how many motions or how many meetings do you have regarding discovery before the return of the search warrant in July of 2021, if that's the date?
not many. I mean, I mean, the murder occurs on July 10th, so there's not a lot of time in between that. So probably 2 at the most.
2, okay. And you don't take any notes on those meetings either?
I don't know.
But I guess I can't figure out, how do you keep track? If you have this list that says all these things are outstanding and you're having these meetings because there's things outstanding, if you're not taking notes at these meetings, how do you know what people are saying and when to expect the discussion?
So if there was something that specifically was known as far as, you know, this is what's going on with this piece, and anticipated sort of ETA on return or something, then yeah, there would probably be a note about that.
All right, so let's assume that the returns came back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021. Are you asking again for the search warrants that you still don't have?
We've been over this time period. I'm trying to figure out you went all the way through arraignment and on the number of meetings and emails back and forth. I get it, but maybe you want to cover new ground.
I'm just trying to figure out, so let me ask a question. So when do you realize that you never turned over the search warrants? When do you realize that?
As far as the 2021?
Back up. When did you get the search warrant in your custody?
In my custody?
Yes.
I would say probably I became aware of it about a month ago.
In 2025?
Yes.
July of 2025 or June of 2025?
Yes.
Is the first time you became aware that you didn't turn over the search warrant?
Yes, if I had been aware earlier, then I would have turned over the search warrants.
But you had your list, right? You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then when did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to ADA Hickman.
Well, let's talk about that. What date was the case transferred from you to ADA Hickman?
I'd say probably somewhere in October or November of 2024.
2024?
Yes.
And how does the case, let me just say in general, how does the case get transferred from one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what needs to get done to transfer a file?
No policy, no.
Okay. So what did you do in this case with Mr. King and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
So I physically took the physical file from my office to ADA Hickman's office.
Okay. And did you have a conversation with her?
Yes.
And did you tell her, hey, there's 6 search warrants that I was never able to get from Trooper Proctor?
Again, if I had known or remembered that the 6 search warrants were still outstanding, then I would have got them and provided them. So no, I did not reference that specifically.
But then at some point, ADA Hickman has to come back to you and say, did you not turn over these 6 search warrants? Say that to you?
No.
She never did?
Nope.
Did you ever have a conversation with ADA Hickman about the outstanding 6 search warrants?
Not until recently, no.
Okay, and what transpired?
Objection. Sustained.
Well, so when you told the court that discovery was almost complete. Did you know when you made that representation that the 6 search warrants were still outstanding?
Objection.
I don't know what time frame we're talking about.
I also, as I've stated in my opposition, I've reviewed the FDRs on this from December and February and the other dates in 2025. That statement was never made. So,
That's
and then
why I want a
December
date. That's why I want a date.
and October as well, when Your Honor set this for trial. Thank you.
So, when's the last time you remember answering on this case?
I believe it was December of 2024.
Could it have been January of 2024?
January 2024?
Oh, so let me back that up. In January 2024, were you still representing the Commonwealth?
Yes.
Okay. And do you remember there being a hearing regarding discovery?
Not specifically, but I'm sure there were.
And do you remember, excuse me, do you remember the court asking about discovery and how the discovery was proceeding?
I'm sure it happened. I don't recall that specific date or what was asked.
Okay. And do you remember telling the court in January of 2024 that you were hopeful that by March of 2024, we could proceed forward because discovery would be complete? Remember that?
I don't.
Okay. May I approach the witness?
Yes.
It's from when? That wasn't even within.
January of 2024.
When I couldn't get. I know. Show you the request. Okay.
May I approach the witness?
Yes.
I'm going to give you the transcript of the appearance before this court on January 24, 2024, and ask you to look on page 5 and tell me, read that the bottom of page 5 to yourself and the top of page 6.
Yes.
Does that refresh your memory as to whether or not in January 2024, you told this court that substantially discovery was complete? There might be 1 or 2 items that are outstanding, but can we get them to us?
I didn't read that portion. I was reading the highlighted portion. If I could have a moment.
Sure.
I'm sorry, I'm not seeing what you're referring to in that
Well, do you remember
transcript.
telling the court, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that to the court?
I may have.
Look at lines 16, 17, and 18 on the document that's in front of you, Ms. Lally.
And what page, Ms. Attorney?
Page 4, lines 16, 17, and 18. The court asks, where are we, Ms. ADA Lally? And you say, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that?
Again, I'm sorry. In the transcript that you handed me, I don't see that.
Let me see, it's a different one. Do you remember, hold on, let me get this right. Do you remember telling the court, I was wrong, you were right. Do you remember telling the court there may be a couple of outstanding pieces, talking about discovery, that I'll check on, and some other pieces that I was speaking to Ms. Coster about, but I think hopefully that by March 11th date, we should be able to proceed forward. Remember saying that to the court?
Do I remember saying that to the court? No. If
Does reading that refresh your memory that you said it to the court?
I didn't read that portion. On what page are we on?
Yes.
You can read from here over to here, to yourself, please.
Sure. Yes, that's correct.
Does that refresh your memory? Maybe allowing that you indicate to the court that, get this exactly right, there may be a couple of outstanding pieces that I'll check on, and some other pieces that I was speaking to Ms. Coster about, but hopefully by the March 11th date, we should be able to proceed forward. Did you say that to the court?
Well, those are two. So does it refresh my memory? No, but according to that transcript, that's what I said, yes.
Okay. And you know at that point that there were still 6 outstanding search warrants that you didn't have?
No, again, if I had known, then I would have gotten them and provided them.
Okay. But weren't we talking about search warrants on this day?
You're talking about 2022 search warrants, which were in a subsequent notice of discovery related to a cell tower dump. You were provided all of those as far as the application, the affidavit, the return, and copies of the warrants themselves.
So we're talking about search warrants.
Separate search warrants, yes.
And nothing's ringing the bell that you didn't turn over 6 search warrants?
Apparently not.
Okay. So the 2022 search warrants that we talked about in court back on January 24th of 2024. At that point, Mr. Kane was indicted. Is that right?
Yes.
Was Ms. Gardner indicted?
Yes.
All right. So what process did you go through to issue the 2022 search warrants after indictment?
Through this court.
I'm sorry?
Through this court.
So you went to Superior Court and asked for these search warrants. Is that right?
Myself personally, no.
Well, did you notify the defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know whether or not there's an obligation on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were.
Do you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment?
Objection. If this is a legal, yeah.
Sustained.
Thank you.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then. Is that right?
Yes.
Okay. And then we come back, we suggest March, and we come back in March. Is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date, so there may be a couple of other additional items of discovery that I need to get and turn over. But otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
Again, I don't.
Finish, Your Honor.
Yes. These transcripts in the FTR, what's on the FTR, what was said by whom, when, is all a matter of public record, and we can look at the FTR and get it. So specific quotes and what was said, what was represented, that's part of the record, and we can see that.
I just have to set it up so I can ask the question that I want to ask, Judge.
Great.
Thank you. So after having made that representation to the court, did you do anything to get the 6 search warrants?
No.
What were the outstanding matters as far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Do you have any notes that would refresh your memory as to what was outstanding at that point?
I might.
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay. Now, other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Okay, but you understand normally we file a pretrial conference report where you agree to give me what I'm asking for, and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay. And you don't remember signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't recall every pretrial conference report I've signed.
Okay. And then we talked about the meeting with the state police. Did you have any meetings with the Milton police regarding outstanding discovery?
In-person meetings? No.
Did you send the Milton police the same type of discovery request that you would have sent to the state police?
Yes.
And did you follow up with the Milton police the same way that you say you followed up with the state police?
Yes.
And did you follow up specifically with Lieutenant Collins?
Yes.
And so what in your mind was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton police turned over to you, would you have kept notes of that somewhere?
Yes.
Would there have been emails back and forth between you and Milton about what transpired?
Yes.
Okay. Did you have any trouble getting information from the Milton Police Department?
No.
When you asked for things, did they return your email and give you what you were looking for?
Yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
And what was that report regarding?
Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that was, I believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Okay, and do you know why that wasn't turned over by the Milton Police Department?
No.
Did you go down to the Milton Police Department and look through their file?
No.
At any point in time when you were representing the Commonwealth, in this case, did you go down to the Milton Police Department and look through their file?
No.
Is that something that you would normally do in a homicide case? Go to the police officer's office and ask for the file?
At what point in the case?
At any point.
Typically, that would be something that I would endeavor to do closer to trial.
Closer to trial?
Yes.
So how could you make sure your obligation was satisfied if you're not meeting with the police until right before trial?
An ongoing duty and obligation that extends even beyond a trial.
Right, that's not my point. My point is if you're not meeting with them and you're not going through their information, how do you know you've turned everything over to the defense?
Because I requested it and I've been given assurances or information indicating that that is what they have.
Let me ask you the same question about the state police. Did you ever go through the state police file while you were handling the case, as opposed to making requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had? Did you ever actually request their whole file to go through it yourself?
No.
Okay.
And can you tell us, was there a policy within the Norfolk County District Attorney's Office of sitting down with police departments, whether it's state police or Milton police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton police box?
It would depend case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months. And is that the first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file and ensure that I have everything that you have.
Okay. And is there any prohibition to that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time. That would have been it at the time, but now I would do that much, much earlier in a case.
Okay. And the state police the same way? Did you sit down with them at some point and look through their file, or you never looked through their file?
No, as his honor just asked, no, I didn't.
Okay. So I guess my question is, how did it work? Did they only look through their file and send you what you're asking for? Or at any point did they send you, here's everything that we have?
My request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything they have, that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in the case.
Okay. So when you go in this case, you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial on September 8th. When were you planning on sitting down with the Milton police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
So by the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton police to go through their file, is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police, is that right?
Correct.
Okay, so when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files, it's on my list of things to do, but I never get down there, you should get out and take a look at the files?
Not that specific, but yes.
What did you tell her?
That, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
So I'm still trying to understand, is there like when the police give you something, do they just email it to you, or is there like a list to say, we gave ADA Lally these documents on this date?
As far as their list?
Yes.
I have no idea what they have.
Okay. So you don't know, as you sit here today, if they have an index of all the things they say they gave to you?
I don't.
Okay. And do you, on the opposite side, have an index of the things you got from them?
It would be contained within those requests, yes.
All right, so at some point, do you print out all your requests and say, okay, let me just make sure I have everything here. I've been requesting something since, December of 2021. I want to make sure I have everything. Do you sit down and do that at some point to make sure everything you requested, you've received?
My general practice would be, yes, and that would be as I know we're getting closer to a trial date.
Attorney Scapiccio, it's a little after 11, and we're going to be able to go until about 11:10. And then I have to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date when we can come back and continue the hearing.
So you're on.
Okay. Attorney Lally, you can step down. Thank you. For the record, I think the defendant's general motion for relevant discovery is docket number 8 in docket number 21 CR 320. That's what we were going to mark as Exhibit 1. It's signed by you, Ms. Capiccio.
It was on behalf of Ms. Gardner.
I don't know. I didn't dig up a motion to join, but in any event, we're talking about what would be otherwise Exhibit 1. It's docket number 8 in the case. All right. Next dates. I would like to have the benefit of your comparison of the old and new, the earlier disclosed and the later disclosed, and how the various items are different.
So,
might I ask also that the court order if they're materially prejudicial to the defendant as we explore discovery?
Yeah, I'm not sure where your microphone is, but if you can, your mic, can you speak right into the mic?
May I also ask the court to order what is materially prejudiced that have
Right.
these materials.
Right. It would be helpful to me if you're proceeding on a prejudice argument to know what it is that you contend is prejudicially late disclosed. Okay. And
Might take a little longer, Judge, because last Thursday, we got some additional discovery from the Commonwealth.
well, let's start in tranches. Okay. We can deal with April and then we can deal with May.
Okay.
And if we have to deal with it in parts, we can deal with it in parts.
So you're right.
But I don't know how much time it's going to take for the parties to get together on this, and I don't know how far out we should look at a date.
And as far as the time frame for the material, how about when counsel filed the motion? Up until that point, I'm not going to.
Mr. McGee is suggesting that which of the documents produced as of the time you filed the motion for sanctions or to dismiss,
Okay.
do you now view as prejudicial? That is to say, and frankly, how you were prejudiced. Okay, this is a witness who's deceased, or we have no way of following up on this, or whatever it is. Okay.
That's only part of the other. I don't want to not meet before that.
Will be.
I mean,
I would like you to do a week, spend a week to try to get back and forth together on these.
Sure.
There's a long list, but it's not voluminous. You can deal with it. You've been through these documents. Each side has been through the documents.
Sure.
So hopefully you can come up with a list. And I'm happy to give you a date when we can continue this hearing.
Sure. How far out do you think we need to go?
Well, it depends on when you can get that list together. I don't know how long it's going to take for you folks to get together, but we could do later this week for continuation of the evidence. We could do the following week, I believe, on the 29th to 30th in the morning. I'm not 100% sure.
Could I bring the other parties in? I think.
Sure.
Another ADA is
sure.
Parties.
We got to make sure we're around.
I know
for
we
this
have counsel here.
hearing.
Another party, so.
I got my pen.
Somebody has the transcripts of all the various hearings.
I do, Judge. I'm happy to share them with everybody.
Yeah, share them with everybody, and let's.
To be literally late last night.
All right, but my point is, in the next hearing, stand up and say Exhibit A is all the transcripts of the various hearings on discovery. That's Exhibit 1, okay, and Exhibit 2 is our reconciliation between the documents, and this is the way in which they're different or new. Okay, and Exhibit 3 is whatever else you want. Here's our discovery report, and here's my discovery motion, and here's the motion. You don't need a witness for that. These are all part of the record, and there's going to be no contest as to any of that. That's just putting in the record. And then if you have specific questions for somebody, ask it. But so I think this can be done in a much more streamlined way, and hopefully we can do it that way. How much more? What other witnesses do you anticipate?
I anticipate Trooper Proctor, who didn't join us today, and I anticipate ADA Hickman. Those are the only three that I've subpoenaed, but based on the testimony, I think we're probably going to need Lieutenant Collins as well, Judge, and maybe Trooper Tully.
Tully and Proctor, bring them out. Lally's coming back, and then Trooper Proctor.
All right, how many witnesses do you think you're going to need?
Trooper Tully here, Deputy Chief Collins, and Officer Benda, regarding the Milton issues, and there's a motion to quash, and I know Your Honor's up against somewhat of a time with respect to ADA Hickman being the predecessor.
Yeah,
counsel,
exactly.
and now counsel of record on the
Give
case.
us Tully and give us
she can answer any
Proctor.
questions the court can.
I can't wait.
That are remaining.
Okay.
From right where she's standing.
We didn't get them in Karen Reed retrial, but we're going to get them here.
And opposing the production of.
All right, so we have 4, maybe 5 witnesses left.
Yeah, that's extra.
We need
exactly.
a day when we can do this in an efficient way. Jim, how does our calendar look?
7/29, which is a Tuesday, is particularly good.
Just how many
Particularly
bad
good.
cops there are, bad law enforcement, like that lady that called in tonight with Mark talking about her son. A tough call to get, and the law enforcement just lying to her. She's,
Well,
there was a reason for that. I'm trying to remember what that reason was.
Tuesday.
We have a noon lobby conference.
there is a lobby
I have
car.
a federal case on, so.
29th is not going to work for you, okay?
How about the 30th in the morning?
We have anything on that morning?
We do not.
No?
We potentially push this to the first week of August.
The 30th is a problem for you?
It is, I can have on the fifth or sixth.
6th is out, 5th is a possibility, but I don't know what we have that morning.
Okay, how about
According to me, the
the
5th
seventh?
isn't good.
That's blocked up. Let's just pull up the list for the 5th. 'Cause I know I am not away that day.
Hector Calderon.
Just listening this at
All
this
right,
point to get
so,
the
It
date.
looks like we could do August 5th.
August 5th, did they say?
Just could, I know that,
Can you do that?
I can.
All right.
Does it work for?
Witness issues, August 5th? That's okay? All right.
so Judge could, I know that, Trooper Proctor's attorney is here. We did serve him in hand today. Could he communicate the new date, so we don't have to reserve him? I don't want to go back to his home.
Morning, Your Honor. Dan Moynihan on behalf of Michael Proctor. He can be available August 5th.
Okay, good. So,
August 5th. Here we go, boys. Here we go, boys and girls.
9 o'clock?
Sure.
I would like to get
9 a.m.
the agreed to exhibits, including the transcripts of any prior hearings, any prior filings that you want to draw to my attention, the reconciliation of exhibits, et cetera,
Root canal day.
in advance.
I gotta admit,
So,
folks, I just finished all my dental work. I am fully caught up. My teeth are actually killing me. I got 2 more implants put in today. The guy was like, last time I did my implants, they didn't hurt when they put them in. This time it definitely is hurting. But I did that right before the interview tonight with Mark. We're going to be covering this August 5th, definitely. Wednesday night, big show. Make sure you're here. Brad Bradley, the brother of Amy Bradley. Amy Bradley is Missing is the Netflix documentary that's like #1 right now. The brother's going to be here on Wednesday night, I think at 6 p.m. I'm redirecting everybody to that right now. It's not tonight. It's Wednesday night at 6 p.m. But I just want to make sure you're aware of that and you can hit the notification. Hit the notification when you get redirected out of here tonight. I want to thank all our mods for being here tonight. Love our mods, Stephanie, Sarah, MJ, Jeno, Scott McGinnis. We got a great crew here. Thank you for all the super chats. Thank you for all the questions tonight and the callers. Sherry D, thank you. We had some great calls tonight as well. I'll see you definitely on Wednesday and Thursday and Saturday, maybe even a little bit tomorrow night. Keep following us and check it out and subscribe, please. And make sure you're here. Check and see if we're popping out every night. Popping up. We do a lot of last minute things. All right. I'll see everyone. Have a good night. Peace.